ಅದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇದಾವೆ. ಸರ್ ಒಂದು ಐಎ ಮೇಲೆ ಸರ್ ಐಎಸ್
Matter for withdrawal, my lordship, kindly have it on tomorrow.
If my lords kindly matter pertaining to FPML and Nostrum, my lords. An interim order was granted by this honorable court, but the matter was supposed to be listed on 7th of March, my lords. It was not listed. Therefore, the trial court is insisting on the extension of interim order. It will be taken up on this Thursday, my lords. Great.
I'm giving a memo in a batch of writ petitions, all fresh matters pertaining to GST, my lord. We have engaged the senior counsel in this matter.
Why do you mention that, madam? Please, in my court, don't do
My
that.
apologies, my
You
lord.
ask for a date, I'll give you a date.
May it be kindly listed for tomorrow, my lord. Much obliged.
My lord, respondents are trying to form road without acquiring the property, my lord. Despite there was an interim order of status quo, my lord. Despite which on Friday they have made markings on the buildings, my lord. I have filed an application for direction, my lord.
Tomorrow.
Sir, please.
Who is the answering respondent?
My lord, PWD department, government has taken notice.
Correct?
Please.
It's already, notice is issued.
Notice has been issued.
The orders list.
Please.
You please mention the number.
please copy.
Mention the number. Give an extra copy or number to the,
Please.
that they will find out if any instructions.
Please,
are-
madam.
This is
Sir, one
media
more copy
matter,
of
my lords.
it.
Previously, this honorable court had directed them to register our Kata, my lords. They are not registered our Kata even after our representation.
Give it.
This is a pending matter.
Give it, date code.
Date may be given, my lords.
16. Adjournments list 1, page number 1, 1 to 4.
Serial number 4, my lord. That the further development has been made, my lord. I have to file a IA for amendment of pleadings, my lord. I have informed 2 weeks, my lord, and I have informed.
List after 2 weeks at request.
Page number 2, 5 to 8. Page number 3, 9 to 11. Page number 4, 12 and 13. Page number 5, 14 to 18.
But serial number 16, notes. Request for 2 weeks, adjournment.
I have informed the other side.
Please, please. I have informed.
I put for it.
Right, it's request list after 2 weeks.
Lord's interim order may be extended.
Interim order in operation extended till the next day.
Serial number 17, my lords. My lords, identical, my lords, issue, my lords, has been heard by the coordinate bench. Lordships may kindly adjourn this by 3 weeks, my lord, because the
Inform the other side.
My lords, present. My lords, interim order may be extended.
After 3 weeks.
Grateful, your lordship.
Interim order in operation extended till the next day.
My lord, serial number 19. The petitioner one was paid, my lord. So we will submit all documents on record. So grant time, my lord.
You must inform the other side.
Yeah. Government.
Relist. Yes.
My lord,
Page number
list to
6, serial number 20 to 23.
Okay.
Page number 7, 24 to 28.
It's 25, my lords, 3 weeks time, my lords. I have to file objections, my lords.
You have informed the other
Yeah, I've
side.
informed, my lords.
At request.
Item number 27, your lords.
25.
27,
Please,
your
ma'am.
lords. That's 27.
27 comes
I-
after 20.
5.
25, na?
List of. The respondent to file their statement of objections by the next date. List after 3 weeks.
Unless the date may be fixed, my lords, for the petition.
25 matter, wait. Let them file, you move the matter. Once they file, you move the matter. Yes,
My apologies, your lords. Item 27. The matter will be adjourned to 6th of February, your lords.
6th of
February.
The Friday.
If not 10th, your lords.
10th of February.
Yes.
Inform the other side.
I have informed already.
Page number 8, 29. List to 2, page number 1, 1 to 6, page number 2.
Take it, your lords. Item 4, connected matter. Maybe adjourned the same date, your lords, 10th of February.
Relist on 10th.
10th.
Give a advance copy to the state.
Yes, your lords. Already served all. The date, your lords.
Page number 2, 7 to 15. Page number 3, 16.
7 and 8, your lords.
7 and 8, same day.
Same date.
Page number 3, 16 to 23. Page number 4, 24 to 31.
Lord, serial number 30, my lords, for the petitioner. Lord, it may be taken upon 5th, my lord. We'll withdraw the said writ petition. We'll file a memo, my lord.
Relist.
We'll have, on 5th, my lord.
On 5th,
Much over.
at the top of the list. Huh?
My lords.
Page number 5, 32 to 34. Page number 6, 34. Page number 7, 35 to 37.
My lords, serial number 37, my lords,
Yes.
Revision.
appearing online. Please, my lords. Can it be taken up tomorrow, my lords? There is one issue which the department had to make inquiry. I'm in Dharwad today. Can it be taken tomorrow, my lords?
Lords, this case, my lords, they have to file writ petition before the Bombay High Court, my lords, because the order is passed by the officer.
So let it come tomorrow, you make a sub.
Please.
Relist tomorrow
Please, deeply obliged. Preliminary hearing, my lords.
in the preliminary hearing list.
Deeply obliged.
Page number 8, 38 to 41. Page number 9, 42. Page number 10, 43 to 47.
Take it, your lords. Item 47 and 48, your lords. Maybe listed on 10th February as well.
47, 48 list on 10.
Published.
Page number 11, 49 to 51. Page number 12, 52 to 54. Page number 13, 55 and 56. Page number 14, 57 to 61. Page number 15, 61. Page number 17, 62 and 63. List to 2.
My lords. List one, not list one, serial number 10, 12, 24, lord, these are all nice matters. List one, lord, serial number 10, 12, dash 9.
10,
10, 12, lord.
10,
12,
12,
24.
12 and
12, 10, 24.
not before me.
My lords, my apologies.
22 also.
20, 22.
My lords, my apologies. Serial number 25, Senior Counsel Tarun Gulati will be appearing, my lords. There is some urgency in the matter. If a date could be fixed and the respondent may be directed to file objections, my lords.
There is no urgency as such. This is a scheme, my lords, they have gone under the scheme, my lords, the application for the availing.
No, correct. You complete your pleadings.
Please, my lords, I request 3
If
weeks.
a date may be fixed, my lords.
I move date.
24th of February.
Serial number 22, my lord, matter pertaining to nice matter, it may be take.
Serial number
22. My request for date, my lord.
It will come, orders will come, then you move it before the court.
My lord's list to serial number 13. I place 2 weeks adjournment.
List to
Serial number 13, your lord.
1, 3.
Maybe on
Raju.
February 10th.
relist. Should not list.
Obliged.
List 2. Fresh matter serial number 1. Serial number 1,
My lords, if I could make a kind
Over
submission.
time, you give up whatever you want to give, you give. Give it, it will come. Yes. Password, madam.
My lord, one submission.
Serial number
Password.
one.
List two, item number
Password.
52.
Mentioning time is over, sir. We'll see later. Password.
Serial number two.
Much obliged. Apologies, my
Serial
lord.
number two, Pradyumna. List two, serial number two, Pradyumna.
Yes, central tax.
Central tax, Mr. Arvind.
List one. List two, serial number two. Welcome.
Arvind and Akash Shetty must be another court lordship.
Central GST.
Ah.
So Akash or Chavan, Arvind Chavan. They should have pressed.
They're coming. Going to
Yes,
come.
Only password, Manoj.
But today no other bench, isn't it?
Manoj, because the date given matters.
Well, Passover.
Please.
Passover.
Serial number three, Chandrasekhar L.
Lord, I seek one, I am filing an amendment application. Such 2 weeks time may be given. Amendment, I have to seek amendment of prayer also.
And request. Relist the matter, date code. 2 weeks.
2 weeks. 9th of February. Serial number 4, urgent. 5, B. Ramesh.
Nice matter.
Nice.
Yes.
Right, not before me, list. ಅದೆಲ್ಲ ಬೆಳಿಗ್ಗೆದು ಅದೇ not before me.
Nice.
Relist before appropriate dates.
6.
Yes.
Serial number 6, Pratibha. P.
Sir, this is second list, not first list.
Your Lordship, this is income tax matter, Your Lordship. This is 148 AB notice has been issued and which is ex parte order has been passed and no reply has been submitted, Your Lordship. So just.
You serve copy. Learned council. Learned council.
Actually.
Dilip,
please.
Accepts notice for the respondent. When do you want it? They're saying ex parte.
Yes.
Tomorrow.
Tomorrow.
If they give copy.
List the matter in
I will
the
give.
same stage tomorrow. Give immediately copies.
Yes, Your Lordship, I will submit.
7, 8. Urgent. Serial number 9, Vijay Raghavan. Serial number 9,
Here for the respondent.
Vijay Raghavan.
I request for 2 weeks, Your Lordships, to file my synopsis and list of judgments. This matter was heard on the last date on the question of jurisdiction.
No, serial number 9.
List 1 or list 2?
List one or list one?
Not correct.
List two.
This case,
No,
my
sir.
lord,
I'm sorry.
I appear for the petitioner. My lord, the petitioners 1 and 2, my lord, are the owners of the properties, my lord, which are more fully described in the schedule. They purchased the property in 94 and 95. They have been in possession of the property, my lord, ever since the purchase of the property. Now, my lord, thereafter, my lord, in 2016, my lord, the BDA started saying, my lord, that you are in the wrong survey number. You have occupied the wrong survey number. The property, my lord, is in survey number 29/2. The sale deed also says, my lord, as far back as 1995, also survey number 29/2. Since there was a confusion that has been created by the BDA, my lord, a suit was filed to, my lord, ascertain whether, my lord, this issue with regard to the confusion, my lord, whether I am in 29/2 or not. My lord, I filed a suit. Kindly see, my lord, the suit, my lord, plaint is at ink page 30, annexed A. The suit, my lord, has been filed as against the BDA, my lord, and second defendant is the vendor. Third defendant is the another party, my lord, who is trying to interfere with my property. My lord, the suit was filed seeking for following ink page 39, my lord. Ink page 39. Lordship gets it, my lord. For a declaration, the suit property is owned by the plaintiff 1 and 2 and is in possession thereof or carved out of and situated in survey number 29/2 and not in survey number 29/3. for a perpetual injunction restraining the first defendant, servants, agents of anybody claiming under them from interfering with the peaceful possession and enjoyment of the suit properties. Well, your lordship may like now the BDA may not contest the matter. Annexure B may not in page 43. They filed the written statement. They filed the written statement, my lord, and then thereafter they denied all this state that averment that is made in the plain. And then, my lord, the court proceeded to adjudicate the matter, my lord, and a judgment has been passed. Annexure C, my lord, in page 54. Now kindly come to, my lord, in page 68 of the judgment. Issues have been framed. Whether the plaintiffs are entitled to seek a declaration that scheduled properties are carved out of and situated in survey number 29 bar 2 of KNR and village, Bangalore, South Kollam. Whether plaintiff prove that they are in lawful possession and enjoyment of the suit properties as on the date of the suit. And my lord, whether the plaintiff prove the alleged interference by defendant number 1, whether the suit is not maintained in the present form, whether the court has no jurisdiction to enter the suit, whether plaintiffs are entitled to the relief sought for. Taking these issues into consideration, my lord, the trial court, my lord, comes to the conclusion that the plaintiffs in the suit are in absolute possession of property. Kindly come to in page 76, my lord. Internal page 23 of the judgment. The documented exhibit P28 and P29, which are notice dated 7/8/2020, issued by the BDA number 1 and 2, go to show that the BDA called the plaintiffs to appear before the authority to answer that the property in which the plaintiffs having possession was acquired for the purpose of formation of work of the layout. The documented exhibit P30 is crystal clear that power of attorney holder of the plaintiff replied to said acquisition officer of BDA, stating that property which was included to form the work of the layout has been subsequently deleted as per the order of the Honorable High Court of Karnataka. The exhibit P39 informal note dated 12/11/2013 issued by the Commissioner BDA goes to show that the property survey number 29 bar 1 and 29 bar 2 of KNR and Village shown as serial number 72 and 73 measuring 30 foot of land is excluded from the acquisition proceedings. So exhibit P39 clearly establishes the fact survey number 29 bar 1 and 29 bar 2 measuring 30 guntas of land has been left out from the acquisition. It means that the scheduled property survey number 29 bar 2 is not the subject matter of acquisition proceedings. Trial court comes to the conclusion based on the document that has been produced and the evidence on record. Then, my lord, the trial court, after taking into consideration all the aspects of the matter, my lord, and the evidence on record, your lordship kindly sees judgment. In page 83.
Page
83. The suit filed by the plaintiff is here partly declared. It is declared that the suitable properties owned by the plaintiff 1 and 2 and who are in possession thereof are carved out of and situated in survey number 29 bar 2 and not in survey number 29 bar 3. First defendant or its servants, agents, officers, or anybody claiming of them are hereby restrained by way of perpetual injunction from interfering with the plaintiff's possession and enjoyment of the suitable properties.
Now this has attained finality.
It has reached finality, my lord, no appeal has been filed, even as on date. Then subsequently, my lord, what happens is, on 6/12, my lord, they trespass into the property, demolish the construction that has been there, and forceful disposition, and then they what you call, demarcate the property and take possession. That, my lord, subsequently what I did was, I should notice them at.
Who appears? BDA? You serve a copy, I'll have it tomorrow.
Please.
Serve a copy.
Please.
Counsel C. Vachan, B. Vachan is directed to accept notice for respondent to AGA for first respondent. Now, any interim relief you are seeking?
I am, my lord, kindly see, my lord, in my interim prayer at in page 24, my lord. The petitioner herein prays this honorable court be pleased to direct the respondents from taking any further coercive steps so as to prevent the petitioner from adopting all measures essential to secure obedience, including restoration of the shell properties in favor of the petitioner, so as to give full effect to the judgment and decree passed in voice number 1703 of 2016, data 3.
Now, who are these private respondents?
My lord, private respondent, second respondent, my lord, is my vendor. The third respondent, my lord, what she does is she files another writ petition. Kindly come to page 107.
107. Yes.
She comes before this honorable court, my lord, files this writ petition and says that her property has been taken possession of. That is her property situated in 29/3. And my lord obtains an interim order. Kindly see, my lord, interim order I produced. That is also before the lordships, my lord, at the ink page 134.
No, so what
Kindly see, my lord.
correct. So what we'll do,
Yes, ma'am. The lordship.
we'll club this along with
Please,
that.
please.
You serve,
My lord, that case, my lord, that is listed on 20th of this month. This particular judgment, this writ petition. I've also filed an impeding application in this writ petition.
shall we club it with that?
Please,
Huh?
please.
Learned, emergent notice to 3 and 4. Petitioners permitted to serve. Counsel will appear for R3 and R4 in WP 37974 of 2025. List along with WP number 37974 of 2025 in the orders list on 20th.
Please. In the meantime, the interim
So
order.
what now? There'll be conflicting interim orders. Now
No, my
they're
lord, no, my lord. They have now seeking interim order in respect of 29/3. I am seeking an interim order in respect of 29/2 survey law. 3794. They kindly see the order, my lord.
So now, just one minute. Now we'll say status quo as on date to be maintained. In light of the submission that petitioner had approached the civil court and decrees passed against the BDA in 1703 of 2016. Then when an order for both parties to maintain status quo as on date, petitioner to file before this court photograph indicating the current status of the property
I produced
along with geotag within 2 days from today. That you file it, let it be in the registry.
That photographs are also there.
Correct, with some that geotag, whatever.
It is there, lord.
Huh? Okay, once more you do it. After the order you file so that it reflects as on date.
10. Serial number 10, Siddharth.
My lord, I appear for the petitioner in this, my lord. My lord, I appear for the petitioner in this, my lord. Lord, notice may be issued to the respondents. I am seeking a very restricted prayer, my lord. I apologize, my lord. Am I audible, my lord?
Yes, yes.
Alright.
Lord Counsel, BDA. Unni Krishnan M is directed to accept notice for the respondent. List the matter in the preliminary hearing list on short dated. Second.
My lord, if I may request on 11th, my lord, seniors not there on
Yes.
attending a wedding.
Now for
Great
this,
for
why do
obliging.
why do you need your senior madam? You're only asking for approval of plan. Let them come
Please, my
there
lord,
in. Yes.
11. Serial number 11. Prashant.
My lord, I have a GST registration which got cancelled by the superintendent. That is in page number 15, my lord. Annexure A. This is for admission, my lord.
Come. Have an extra copy?
Yes, my lord.
Yes, please. Yes.
Yes, my lord. So my GST has been cancelled as per Annexure A, which is in page number 50. So the reason is I have not filed my GSTR 3B. So for which there were notices which can be seen in Annexure C1 and C2, my lord. This is in page number 20 and 21. So this GSTR 3B was not filed for January, March 22, 23 in C1, and subsequently in C2 for April to June 2023 and 24, I have not filed. That is because of wrong advice from the professional. So after that, I realized and I filed an appeal.
Okay, find out. Lord Counsel. Appeal, what happened?
Appeal was rejected because of they could not condone the delay, and hence I am here, my lord.
Find out.
I am
Akash
doing the
Shetty.
business and.
Yes, short date. Akash Shetty accepts notice for respondent 1 and 2. List the matter on.
1 week.
On third.
12. Serial number 12.
May I, Your Honor? Your Honor, the issue is with regard to rejection of condonation of delay by respondent number 1, Your Honor.
You have an extra copy?
Already served. It's served on.
I'll take notice.
No, Counsel Philip accepts notice for the respondents. What is the point?
Your Honors, the petitioner owned a piece of land which was compulsorily acquired under National Highways Act, Your Honors. And the petitioner filed return of income without being aware of the fact that the same amount is exempt from income tax under section 96, Your Honors. Further, during the course of assessment proceedings, the proceedings was initiated by the issuance of notice under section 143(2). And during the course of proceedings, the petitioner passed away, Your Honors, and later on, the petitioner was represented by legal heir of the petitioner. On awareness of the legal heir filed for a request to file revised computation of income before the assessing officer, Your Honors, and the assessment order was passed stating that the same is not exempt from income tax, Your Honors, under section 105 subsection 3. Further, an appeal was preferred before Commissioner of Income Tax Appeal, Your Honors, wherein the appeal was dismissed, stating condonation of delay is required to be filed before the respondent number 1. The same was filed, Your Honors, wherein respondent number 1 rejected the condonation of delay, stating that the said amount is not exempt from compensation without getting into the reason for delay, Your Honors.
You have to file an appeal. How are you coming by way of a writ?
Your Honors?
You may have to file an appeal. Why are you coming by? Your appeal is rejected.
Your Honors, we have filed the condonation of delay application was rejected by the respondent number 1, Your Honors.
Even otherwise, my lords, on merits, my lords, it's division bench in Dharwad, my lords, has held in our favor. Wherever the acquisition is under the national highway, my lords, it's not exempted is what, my lords, the division bench has already held.
Your Honors, we have a decision of coordinate bench wherein it is stated that
Not under the highways, my lords, that is under different act. And National Highways Act, my lords,
Give a advance
I'll
copy
serve a
to
copy.
give a advance copy to her. We'll have it next week. Let us.
Your Honors, may it kindly be taken on February 10th or 11th, Your Honors.
10th. This is the matter in preliminary hearing list on 10th. 10th or 11th. 11th. Dilip accepts notice for the respondents. They are saying it's covered by a division bench judgment. You collect it and have a look at it. It's covered, it's covered.
Much obliged.
13 urgent. 14. Kusuma M.
Appearing for the petitioner, my lords. My lordship, this is a Muda notification 15/7/1997, and afterwards they have issued a final notification. But award nothing, they have not taken any physical position. But in our endorsement, they have not mentioned that they have issued a final notification with respect to my survey number. That's why I am not mentioned in the petition. My lord. Kindly we notice similar matter is been listed on 29 of this month.
AJ accepts notice for first respondent, Muda. GM Anand is directed to accept notice for the second and third respondent. This is the matter on 29th.
29-1.
29th.
16th also the same notification. Serial number 16.
16,
16 and 17. 16 and 17 also.
16, 17, same order.
Yes, ma'am. Kindly listed on same day, 20.
That's for the petitioner. I come before my lords because my application seeking condonation, my lords, under 1192B has been rejected, my lords. Page number 215, annexure P. Annexure P 215. Last annexure. That's what is the ground for which it has been rejected as my lords. I have filed it after 5 years of the concerned assessment here. But my lords, what has not been taken into consideration, I have sought for rectification of my returns of the year, my lords, assessment year 18-19.
That is still pending.
That is rejected. That is rejected. That's what my lords are seeing at annexure P 215 is the order of rejection. Now, that's what has happened is from 2018, I've been following it up with the department. Now, my lords, the circular which they rely upon, can I just pass on the circular?
1192B is rectification.
No, my lords, 1192B is the condonation. Can I just pass on the circular for a moment?
What happened to your rectification?
It's rejected. My lords, that consequently gets rejected, my lords, because of my condonation cannot be accepted, my lords. So my
your rectification was filed first.
Yes, my lords. My lords, can I? This is circular which they rely upon, my lords, which is dated 1st October 2024.
No, but just tell me what is the fact. When did you file rectification?
My lords.
No, assessment order was passed.
No, assessment order was not passed. No, my lords, what happened is I filed my returns for the year 2018-19, my lords. And my lords, 5 categories of income, totally amounting to 3 crore 38 lakhs, my lords, was, my lords, an exempt income as per law. My lords, by mistake, my lords, when I was filing it through my accountant, I filed it under the head, my lords, taxable income as dividend. But subsequent to which, my lords, I received an intimation, my lords, which is at annexure C, saying that I am liable to pay a tax of 71 lakh, which, my lords, is of 2020. Subsequently, my lords, from annexure D onwards, from 2020, I have been seeking the rectification with the concerned authorities. That's when it got rejected. They asked me to go file it before the concerned JAO, Jurisdictional Assessment Officer, my lords, assessing officer. I went and filed it. By the time I went, my lords, this circular had come into force, which is 1/10/2024, which said, my lords, 5 years and above, I cannot seek for rectification.
Para?
My lords, second page, my lords. No condonation application for a claim of refund loss shall be entertained beyond 5 years from the end of assessment year for such application is made. The time limit for such filing of such application within 5 years from the end of assessment year will be made applicable for applications filed on or after 1/10/2024. The limit of 5 years shall be applicable to all authorities having power to condone delay. That's my only request is twofold, my lords. Number one.
When was it returned? When was your application returned rectification?
My lords, finally I filed my application, my lords, in the year 2025, my lords.
No, earlier you said you had sought to file and they.
Yes, my lords. That my lords would find it at annexure D, page 49.
This was filed when? This
On
was
10/9/2020, which my lords, if my lords may turn to page 49 for a moment, on top of it, there's an acknowledgement number. That's the last 5/10/9/2020.
That's the date.
That's the date.
This was for rectification.
That was for rectification.
Then they returned it saying you go before the.
They didn't say that, my lords. They just rejected it. They just.
Where is that?
That's that, my lords, would find it at page 125. Page 125, Annexure E. That's not. It was an automated system, my lords. They rejected it. It is not checked by an order by an assessing officer. The CPC rejected it, my lords. Again, my lords, thinking that it might have been a mistake, I again filed it. Again filed my rectification, my lords, at page 126, my lords. Annexure F. My lords, I met with the same fate, my lords, at page 198. Annexure G. Same CPC order itself.
Rejected on?
My lords, that, my lords, 14/10/2020.
Page?
Page 198. Again, my lords, it's an automated reply. It's not a reply, my lords, which has been passed by an officer. Though, my lords, there's a digital signature, but it's automated. Then, my lords, at page 199, I'm sorry, 198. And 199, my lords, I filed a grievance application because I did not know where to go. And how do I proceed forward with?
You filed an?
Grievance application, my lords, which my lords would find at page 199 at Annexure H.
Yes.
There, my lords, in the grievance description, the last two documents which my lords saw, that is September 10, 2020 and October 9th, 2020, that is mentioned. Again, my lords, at page 200, I seek for an adjustment, my lords, by saying that there was a typographical mistake. It is a clerical mistake at Annexure J, page 200. That request also, my lords, gets rejected at Annexure K, page 203. On the same day. Again, my lords, automated. And my lords, at 205 Annexure L, I get a reply, my lords, saying that there's no grievance. All your grievances have been redressed by automated process, my lords. It's been rejected, so all your grievance has been resolved. Then, my lords, when I went, my lords, and I sought for some clarification, my lords, I was informed that I should be filing an application before the concerned JAO. That, my lords, I filed it on 19th August 2025. Page 207. And, my lords, my condonation, my lords, which is under 119(2)(b, is at, my lords, page 211. And, my lords, if I can just take my lords to one page number here at page number 212. Page number 212, my lords are on. My lords, that tabular column which my lords are seeing is the exempt income. Now, my lords, I get an order at page number 215. All these things get culminated, my lords, by referring to one circular which I've just placed before my lords, by saying, owing to the circular, which is dated 1st of October 2025, I am rejecting your application. My lords, I am only before, my lords, if I have to go on law, my lords, I should say that, my lords, the circular is not even applicable to me, because that, my lords, is for carry forward of loss. My lords may see the title of that. To admit an application or claim for refund and carry forward of loss in set off thereof. I should say that it's not even applicable. Let's rehouse that. I would keep that aside for a moment. That's my request is that, my lords, let the delay be condoned. Let them, let's process the application on the merit. What is the one which I have filed? If I'm entitled for that particular rectification, let them, only on this particular circular, my lords, they can't reject it.
It's page 125. Your Lordship. Lords, this is the rectification. On the rectification application, we passed the audit. Lordships may kindly see the audit, which is in bold under section 154 of the Income Tax Act. Rectification application can be filed only to correct the mistake apparent from records. In this case, fresh claim of relief or withdrawal of relief has been done in rectification application. This change is not a
Let
mistake.
us see.
This is an appealable audit.
Which is what is the error? Just demonstrate.
Well, that's the error, my lords, which I just showed, my lords, at page number 212.
No, in your return.
Lords, I have not placed my returns on record.
You place it, let's have a look, at least prima facie.
Yes,
what you are saying is admittedly exempt, which was a wrong declaration.
Yes, my lords,
That
I will.
Prima facie convinced, we'll see what is.
Yes, my lords, I'll place it on record.
When do you want?
Let's have it tomorrow itself.
Tomorrow.
Lords, they can file an appeal against this.
No, so let us see what is that mistake. Let him demonstrate. If you are able to show prima facie, then otherwise you will have to go on appeal.
Yes, my lords.
It should not involve much of a exercise.
Yes,
If
it's
you
only,
could-
my lords, I need to demonstrate comparatively that.
What is that mistake? Which
This should not
according-
have come here. That's all I should demonstrate.
should.
I should have got the returns, my lords. I didn't enclose it.
Relist tomorrow in the same stage.
Same state, same list. my lords.
List, I don't know. But we'll take it up and see.
Grateful, my lords.
16, 17, 18, Raghavendra Gowda.
Petitioner she is seeking to set aside the general award and to pass consent award. Matter is covered by my lord's judgment.
Serial number 18, 19 and 23.
That could be
18.
Oh, sorry.
19.
19 and 23. My lord.
ಅವ್ರದ್ದು ಕೊಡು. ಅಲ್ಲ ಅವ್ರದ್ದು ಕೊಡು, discord.
18, 19, 23.
18, 19, 23.
This one will do, is it?
Yes, same thing. I've given your lordship's hard copy.
Yeah. Same order. Then Council P.V. Chandrasekhar accepts notice for the respondent. Number
2 and
2 and 3, AGF for 1. Same order. Same order. 18, 19,
23.
23. Yes.
Grateful.
20, serial number 20. Serial number 20.
I pray for the petition, Your Lordship. Your Lordship, the impugned annexure is at annexure A, where my application for non-agricultural conversion into residential conversion has been rejected on the recommendation of the respondent BDA. They cite that my land is required for future acquisition for a formation of a layout undertaken by the BDA. Therefore, my application should not be processed and should not be converted. If I may be permitted to read the relevant paragraph, Your Lordship.
So you take out notice.
Your Lordship. And the matter is also covered by the judgment at annexure J, Your Lordship.
Annexure
J. At page 285, Your Lordship.
Paragraph.
If I may bring Your Lordship to paragraph number 10, Your Lordship.
Yes.
Nevertheless, having regard to the law laid down by the Honorable Supreme Court in the case of T. Vijay Lakshmi, it is clear that the right of a person right to property of a person would include the right to construct a building. However, such right can be restricted as a reason of legislation. The apex court held that the provision of the Karnataka Town and Country Planning Act and Comprehensive Development Plan, which prescribes a particular usage of the land, having regards to land development, there can be no difference in the opinion that the competent authority would be bound to ensure the implementation of the provisions of the Act of the Master Plan. However, in this case of T. Vijay Lakshmi, the application that the petitioner was rejected on the premise of a property in the question will fall in the valley zone in the proposed comprehensive plan. The Honorable Apex Court has held that the law applicable on as of date should be implemented. A proposal for modification in the master plan cannot be a ground to reject the application. Therefore, it was held that the rights of the parties cannot be intermeddled with so long as an appropriate amendment in the legislation is not brought into force. The determination of such a question or consideration of the application cannot be postponed to take away the valuable rights of the party. The Apex Court therefore held that it is now well settled that an application for a grant of permission of construction of building is required to be decided in accordance with law and the law applicable on the day on such permission is granted. However, the statutory authority must exercise its jurisdiction within reasonable time. Therefore, going by the information provided by the impugned communication of the BDA recommended to the state government on 7/3/2024, a proposal to acquire the lands in various villages, including Kenchapura village, where the land in question is situated. And however, the state government has not issued any such notification for acquisition, the deputy commissioner cannot postpone the decision in the matter of granting permission under section 95 of the Act. In fact, the prescription in 95 is that the case in which the deputy commissioner fails to give his decision or issue the order within 30 days from the receipt of the application, the approval of the diversion for use shall be deemed to have been granted by the deputy commissioner.
So in your case also state has not passed notification.
They've rejected it, saying that on the recommendation of the BDA, we are rejecting it. They've issued an online endorsement order.
Where is the endorsement?
Endorsement order is not produced with the petition, Your Lordship. However, I'll produce it tomorrow.
Produce it. You have to challenge the endorsement, isn't it?
Your Lordship. Problem is, Your Lordship, they've issued as an online endorsement, and that has been issued without the date which the endorsement was issued.
Correct, but nevertheless, that is what is your grievance, isn't it?
Your Lordship.
So you produce it. Meanwhile, you serve.
Your Lordship. A short date to be fixed, Your Lordship.
Yes. AGA accepts notice for first and fourth respondent, BDA. Yes. In that matter, who appeared for BDA?
That matter, Your Lordship,
Vachan is directed to accept notice for the respondent number 2 and 3. List the matter in the preliminary hearing list on 9. You serve copies immediately.
Lordship, a short date, Your Lordship.
Come on, 9.
21.
Great.
For the petitioner, my lord. This matter arises under the provisions of GST Act. I have filed 3 replies without considering any reply. The order has been passed, my lord, and the sole ground is mismatch of input tax with output tax. I have also filed the chartered account certificate stating that the tax has been paid by sellers. Chartered account has given the certificate, and my entire turnover is outside the purview of.
My lord, this matter actually, my lord, I have read morning only file. It is an ex parte order. We have given portal notice also and personal hearing also. They have not appeared. But now by coming to the court,
so tomorrow
is misplaced, my lord.
Tomorrow or some other day?
My lord,
we'll have it tomorrow. We'll have it tomorrow.
Or else today it can be disposed of. Kindly be passed over. I will just verify which annexure I have to assist before this honorable court. That's all. My endeavor is to assist.
We'll pass over or have it tomorrow? Pass over.
22. Maitreya Krishnan, objection.
Not appearing for the petitioners. A very short question here is the entitlement to interest, my lord, for compensation. Acquisition was of the year 2006-2007. The petitioners, my lord, the claimants, my lord, there was an interstate dispute insofar as the entitlement was concerned. A partition suit comes to be filed, my lord, which is then disposed of an RSA in a compromise petition. The KADB, my lord, during this entire time, they don't deposit the compensation in the, as per section 31 in the court. We are then compelled to come to this honorable court, my lord, saying that compensation has not been given to us. This honorable court, my lord, at annexure J, page 68, passes an order, my lord, at page 70, my lord, para 4. In view of the matters, the grievance of the petitioners with regard to seeking compensation in terms of the compromise arrived at the parties as such, the third respondent is directed to consider the representations dated 12/6/2023 with reference to so and so. This, my lord, was not done. So then we went in contempt, my lord. When we went in contempt, my lord, an affidavit is filed. That's at page 95. Broadly, what the KADB is now saying, they are telling the petitioner, you please accept this compensation now, but we are not going to give you interest. So the short question is, my lord, is the entitlement of interest. That's
Who appeared?
Mr. P.V. Chandrasekhar, my lord, appears in the contempt on the first round and in the contempt petition. He still appears.
He doesn't. He's not keen on accepting notice in your case. P.V. Chandrasekhar accepts notice for respondent
2 and 3.
2 and 3.
3.
EGA for first respondent. It's only on the interest count.
Only the short question, my lord.
List in preliminary hearing list on
9.
Now the office objections.
My lord, I'll clear
we
it.
complied with in the interregnum.
Please, grateful.
23 dispose of after the second time. 24 Praveen.
The office objection is
DB party.
I appear for the caveat. The fifth, the preliminary notification and the final notification is not being challenged yet. The interim prior, the annexures is not made is the, if Honor's permits, I would pass on the same with the memo for preliminary notification.
You are?
Lords, their only main relief is to seeking a direction to consider their representation to the effect that award be made under the new enactment. Now, my lords, I'm already informed, I gathered after the caveat was listed, we asked our officials, they have issued an award and issued a 12/2 notice. Now, my only submission, my lords, is let it be open for him to seek enhancement there in accordance with the latest law that serves purpose for everyone. Incidentally, my lords, we have allotted this to Lamb Research, which is a subsidiary or a sister concern for Foxconn, and there the land acquisition is being derailed, my lords.
No, no. Compensation is calculated in terms of
They have given a 12/2 notice is what I'm informed. 12/2 is under the old act 1894. Now, of course, my lords, there has been an amendment. The other issue is they will have to probably challenge the old enactment or the award made under the old enactment before this court and seek an annulment of the same, because till that time I'm a functus officio, I can't do anything, my lords, because I've already passed the award. Now, rather, my lords, let him be given liberty to seek an enhancement. In the enhancement proceedings, let him seek enhancement as per the new enactment.
Let us see. Now, you complete your instruction. I'm not passing any interim order.
Please.
But you just point out what is the change in law, etc.
Please, my lords.
See, normally he should go before the appellate authority. That is the rule, no doubt. But is there something so apparent that could be solved here? Let us have it.
I'll candidly agree, my lords, that is apparent because of the simple reason that my enactment is amended in 22 and the old act provisions are now not available.
Correct. So what you do, you produce a copy of the award. I'll have it next week, and we'll see what order to be passed.
Please.
And council.
Kindly a date may be fixed.
Yes, yes.
A date may be fixed.
Relist in preliminary hearing list on 9th. Office objection is overruled.
Oh, obliged. Deeply obliged. Deeply obliged.
And you inform them that in all such matters, but you can't do it on your own. Yes.
Obliged.
In this case, my lord, I accept notice for respondent number 1, my lord.
AG accepts notice for the first respondent.
Please.
25.
Obliged. Obliged.
Special. Pass over.
26. 26.
This petition is filed seeking to quash the preliminary notification as well as the final notification.
Office objections.
Maybe
Long-
it
long
has been
list.
complied with.
A long list.
Actually, it is complied with.
Just
Is complied with. If at all there is,
example. Long list is there. Just.
these are all complied with.
Huh?
Complied with. Again, further office objections are raised, I think. It may kindly be, I mean.
No, but I can't waive off all those objections. That
Keeping open this, it may be.
What?
Faceless proceedings. With respect to the office objection, the short date is given, it's listed on Friday.
Office objections to be complied with. Relist the
Meanwhile,
matter.
notice IT.
So what is the office objection? If it's minor.
Office objection, one is a court fee, my lords, I've remitted the court fee.
Huh.
And with respect to the other office objection, my lords, that is a synopsis chronological date wise. One date, my lords, has been wrongly mentioned. And
So now, depending on who's the counsel, you give advance copy. I'll have it on next Tuesday. You serve an advance
I'll
copy.
serve.
Relist in fresh matters list on Tuesday. Office objections to be complied with in the interregnum. Meanwhile, you serve.
I'll answer. Great.
Personal matter, serial number 1, Parasuppaya BG.
My lord, appear for the petitioner. One of these that matter where the state has been double taxing the petitioner, my lord. For which I'm producing the endorsement.
This central tax, is it?
No, my lord, state.
State.
For the same period, it's been double taxing, my lord.
Just one minute, just. Second list, one.
Second list, first list, my lord. First list, one.
First list, second list.
Oh, sorry.
Parasuppaya BG.
Also, very good. Huh?
My lord, second list, serial number 1 is, I think, central government. They have to serve, supposed to serve Jeevan there.
Paul Subramaniam. My lord, he just served the copy, my lord. He's not there.
Any interim relief or what?
I'll just see. Radiant inform. My lord, this is, they have raised one ground about this Chinmaya Seva Trust. It is covered by my lord's judgment.
Then we could dispose it of only. I'll fix a date and you find out.
Yes, my lord.
If it is the same.
Yes.
You find out. We'll fix a date.
Yes, my lord. This Chinmaya only, my lord. This Lord's Maya.
Okay, Land Council G1 accepts notice of the respondent. So when do you want it? Next week or tomorrow?
Tomorrow, your lordship may have it, my lord.
What's the matter? In the same
Just go through
page?
the papers once, my lord.
Tomorrow.
Serial number 2.
Notice, I may be directed, take notice.
Land Council G1 is directed to accept notice for the respondent. This is the matter in the same stage tomorrow.
Nale date ಎಷ್ಟು?
Yes.
Lots order passed under 73(9) of CGST Act, my lords. It's an ex parte order. I was not served with the notices, only seeking a remand.
So just tell me the relevant facts.
Please, my lords. So show cause notice, my lords. Show cause notice dated 27/11/2024, my lords, was issued. It was uploaded. Lordship, my apologies. I was another court, Lordship. Show cause notice was, Your Lordship, uploaded on the GST website, the GST and in his portal, Your Lordship. Then now one problem, practical problem is that, Your Lordship, all the matters are interest to the auditors because every month 2 returns have to be filed under GST, unlike service tax where only 2 returns per annum. Now all returns of work are interested to the auditors. The auditors will not take 1 or 2, 20, 30. So they will have to scan through all additional notices or notices whichever are reflected in the GST input, which they seldom do. Now, when I received the order, I approached him. They said it has been uploaded in the GST portal and I downloaded. Now, with regard to fixing of 3 hearings, Your Lordship, which Your Lordship may find,
can there not be a system where along with uploading in the portal to the registered mobile number of the SSC or his auditor if he has furnished, you can send an alert.
That alert is, Lordship.
So that some small thing will go a long way in
Please, Lordship.
them coming.
That's
So the client, now the auditor works for a fee, the client works for his life. If he has to pay from his pocket. So you send both an alert, you find out if something can be done at the level of your higher ups. But don't leave it so that small things we can avoid. Yes.
Lordship, one more submission on page number 28. It is held that 3 personal hearing opportunities were granted on 3 different dates, and the finding is that he has not appeared for the hearing, Lordship. Lordship, I kindly see the screenshot of the notices which are reflected. Their hearing intimations are not figuring, Lordship. That means hearing intimations.
Page 28 at
Page 28 and page number 42, Lordship.
at paragraph
Page number 28 at paragraph, Your Lordship.
10.1.
Yeah, 9, paragraph 9, Your Lordship. It is held that you are not appeared for 3 personal hearings as per section 75. In fact, 3 adjournments can be granted, within 4 minimum hearings. There is one aspect. And these 3 hearing intimations were not uploaded in the website, which is forthcoming from page number 42, Lordship. The screenshot, Lordship.
This is not in the portal. Also.
Not in the portal. Not reflected. While order and show cause notices are there, this is not there, Lordship. Hearing intimations.
So now it goes back to what stage? Reply to show cause.
Reply to show cause notice.
Now this putting it in the portal is only in the central one or state also same? State. So then you can ask both and you see, you can make some circular something like the petitioner is called in question. You must pay the auditor well.
If they pay the auditor properly, Lordship, that mistake you won't commit. This is
the petitioner. Like a cause list alert, if you register the mobile, so whenever you send a notice and put it in the portal through your automated system, let it go to the registered mobile also. The petitioner has called in question the validity of the order of adjudication at annexure A passed under section 73(9). 73.
73(9).
73(9). It is the case of the petitioner that proceedings have culminated without any reply to the show cause notice.
Please.
And in effect is an ex parte order. It is submitted that the notices are stated to have been posted in the portal. The show cause notice is stated to have been posted in the portal, but there appears to have been some lapse on the part of the auditor. Full stop. It's further submitted that insofar as notices of personal hearing though it is observed in the order that dates for personal hearing was fixed on 2/1/25, 27, 1/25 and 6/2/2025. A verification of the portal would indicate that notices for personal hearing were not uploaded in the portal.
Please.
Learned counsel appearing for the respondents is unable to controvert the assertion that notices of personal hearing were not communicated. Full stop. Noticing that the order has proceeded and culminated without any reply on merits to the show cause notice, it would be appropriate to afford one opportunity to the petitioner to participate in the proceeding. Full stop. Accepting the lapse, accepting the explanation of the petitioner, it would be appropriate to set aside the order at annexure A and remit the matter back to the stage of reply to the show cause notice. Petitioner, first. Next. Only A goes.
Please, Worship, only A.
All contentions are kept open. Petitioner to be to mark his presence before the sole respondent on without further notice and make out reply. Needless to state, if opportunity granted is not made use of, petitioner would, by appearing on the date fixed, petitioner would lose the benefit of indulgence granted by this court. Date. Yes.
Refund.
Next one, fresh matter serial number 1, Mahesh Kumar R. Mahesh Kumar.
That's all for the petitioner.
Central tax, is it?
Yes, my lord. And this is a double tax matter, my lord. For the period which already paid, they have initiated the criminal proceedings, my lord.
No, state council.
Who are the parties?
You.
Who are the parties?
Assistant Commissioner of Commercial Tax Department. Shumar.
Yes.
My lord, page number 40.
Yes.
That's an application filed under section 42, subclause 9C. So they stated the year 10, 11, and 11 and 12, which is already been paid by the petitioner. So for which I'll be filing an endorsement, my lord, is given by the Commercial Tax Department.
The problem is, Your Lordship,
Put it.
Annexure P1, my lord. Page
Annexure
number 1.
P1.
Yes, my lord. P1, like page number 2, my lord. The purchasing and input tax. And page number 3, the VAT calculation, output, tax payable, the year 10 and 11, 11 and 12, which has been already paid by the petitioner. So these are double tax proceedings which has been initiated by the state, my lord.
You already paid?
Yes, my lord. This is endorsement given by the commercial tax itself, my lord.
This 1,19,000, page 3.
Yes, my lord. Yes, my lord. I mean, even they have been listed the check number, and as well as we have been paid the penalty of 10,000. That is in the form of check on dated 21/8/12. So this has been paid. So the same thing has been initiated now, my lord.
For the same period?
Same period. Same period, my lord. Application is the same period.
Find out. You find out.
So that's all I have been furnished
Your
all the.
Lordship, permit annexure A, page number 16, my lord. Para third paragraph, my lord. If your lordship permit, shall I read, my lord? ದಿನಾಂಕ 9/3/2017 ಪ್ರಸ್ತಾವನಾ ನೋಟಿಸು ಕರದಾತರಿಗೆ ಜಾರಿಯಾಗದೆ ರೆಫ್ಯೂಸ್ ಟು ಅಕ್ಸೆಪ್ಟ್ ರಿಟರ್ನ್ ಟು ಸೆಂಡರ್ ಎಂಬ ಷರತ್ತೊಂದಿಗೆ ಕಚೇರಿಗೆ ವಾಪಸ್ಸಾಗಿರುತ್ತದೆ. ಅಂದರೆ ಗುತ್ತಿಗೆದಾರರು ಉದ್ದೇಶಪೂರ್ವಕವಾಗಿ ಪಡೆದುಕೊಳ್ಳದೆ ತಿರಸ್ಕರಿಸಿರುವುದು ಸ್ಪಷ್ಟವಾಗಿರುತ್ತದೆ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿ ನೋಟಿಸ್ ಗುತ್ತಿಗೆದಾರರಿಗೆ ಜಾರಿಯಾದಂತೆ ಎಂದು ಭಾವಿಸಬಹುದಾಗಿರುತ್ತದೆ. ಆದಾಗ್ಯೂ ಸಹಜ ದೃಷ್ಟಿಯಿಂದ ಪ್ರಸ್ತಾವನಾ ನೋಟಿಸನ್ನು ಸಾಮಾನ್ಯ ಅಂಚೆಯ ಮೂಲಕ ರವಾನಿಸಲಾಗಿರುತ್ತದೆ. If you matter may be remanded, he will
that itself
there will be a specific direction because we have to verify the facts of the case. It's a
Correct. Now
ex parte order it is.
Okay, so I'll have it next week. You get instruction. If it is so that your officer verifies and let him appear also and point out. If it is so, we'll see. I'll have it next
For
week.
only, my lord.
Tomorrow.
I will verify.
There is an interim order now.
Because what happened, Hem Kumar matter, ಅದು confusion ಆಗಿ ನಮಗೆ files misplace ಆಗಿ ಇದಾಗಿಲ್ಲ. This is easy. Tomorrow may be
double
taken, my
taxing
lord. I will
matter, my lord, they have been.
No, correct. We agree. Just let them verify it.
Yes, my lord.
HCG
And meanwhile, my lord,
the respondent. Release tomorrow. We'll
Much
close it. If you have any clarification, you
Yes, my
furnish.
lord. I will see.
If there's any clarification, you please.
Yes, my lord.
Give them whatever.
I will.
Number 2, Reshima.
The only office objection was that I had not paid the court fee that has been paid. Office objection may kindly be overruled, minutes.
Counsel for the petitioner submits court fee is paid. In light of the same, you have paid it.
Please, I have the receipt as well.
You file it up with a memo.
Very well.
Copy. Counsel for the petitioner files copy for having remitted the court fee. In light of the same, office objection is complied with. The interim order earlier granted is extended till the next date. Respondent to complete their instructions.
Grateful, minutes. I'll file it during the course of the day.
Yes.
Number 3.
Please, my lords, I'm appearing in item number 3, my lords.
Yes.
The office objection was that a certified copy of the impugned order was not filed, my lord. On the previous date of hearing, my lord has granted me an exemption from filing that copy, my lord. It is Annexure AF, my lord. The matter was otherwise placed for orders today, my lord.
Yes. Who appears?
I appear. Serial number 3, my lord.
Yes.
First please. My lord, tribunal not yet formed, my lord.
My lord, that is not the issue here, my lord. Otherwise, what has happened is that, my lord, I was a consignor of the goods. Thereafter, my goods were intercepted by the respondent department, and thereafter a penalty was imposed upon me, my lord. In the original order, my lord, the penalty under 129(1)(a) and 129(1)(b both were mentioned, and the amount that was determined was under 129(1)(b). I filed an appeal on merits, even though, my lords, my appeal was rejected. The appellate tribunal came to the conclusion that the penalty should have been imposed under 129(1)(a) and not 129(1)(b, for the reason that I am the consignor of the goods and I had come forward to pay the penalty, my lord. Thereafter, my lord, I applied for a refund application after the order was passed by the first appellate authority. My application is still pending till date. This application was filed back in 2023, my lord. I filed a right to information. I filed an RTI that why my application has not been processed. And once my RTI came into picture and I received the information, my lord, it was informed to me that no physical approval was given for a refund, my lord. Thereafter, my lord, a stay has been imposed upon that particular order in my favor, which is at Annexure AF, my lord, against which I am before, my lord, granting an ad interim stay, granting an ex parte stay, that without giving me any notice, without following the procedure of law, simply for the reason that I had applied for a refund, my lord, under section 108, which is for revision. the exercise of power in this case, my lord, is completely arbitrary. The department has proceeded in a high-handed manner without serving me a notice. They have granted a stay to to themselves, saying that effectively stopping my refund application from being processed in any manner.
Annexure AF.
Yes, my lord.
Page.
If I can read it's at page number 137, my lord. If I can read the operative part, which is at page number 138.
150.
137, my lord, the order starts. (137) Annexure AF, my lord. This is the impugned order, my lord, which has been passed. I am reading from paragraph number 5 and 6, my lord.
Yes.
At page 138, the submission made by the Joint Commissioner of Commercial Taxes Admin, DGSTO 01 Bangalore wide letter dated so and so is verified, and with reference to the appeal order passed by FAA, which is the first appellate authority, and prima facie it is observed that the order passed by the FAA appears to be erroneous and improper insofar as it is prejudicial to the interest of the revenue, and it is felt necessary to stay the operation of the order passed by FAA. Para 6, therefore, to verify the correctness of the order of FAA in appeal number so and so, dated so and so, and in interest of revenue, I hereby, with the power vested in me under section 1081 of the KGST/CGST Act, pass the following order. The order now states that, my lord, the operation of the appeal order passed by the Joint Commissioner of Commercial Taxes in the case of Messrs. Stalwart Alloys India Limited is hereby stayed until further order. I have not received a single notice before passing the order. I have not received a single notice after passing this order, in fact, my lord.
What is the procedure for exercise of power under 108?
Please, my lord. My lord may have, I have reproduced the procedure, the rules which are there, my lord. My lord may have page number 22, my lord, of my petition. My lord, yes. I'm reading rule 109B, which is there at the bottom of the page, my lord. Notice to person and order of revisional authority in the case of revision. Where the revisional authority decides to pass an order in revision under section 108, which is likely to affect the person adversely, the revisional authority shall serve on him a notice in form GST RVN 01 and shall give him a reasonable opportunity of being heard. That is
correct. Now, it appears that that refers to a final order to be passed under 108. What we could do is we could remit it back and fix a time frame for them to decide, unless you are saying that this is one without jurisdiction. Now, under this 109, it appears to indicate that this is a procedure to be followed when a final order under 108 is to be passed. Suppose they were to revise the order, which is a subject matter of the revision petition. So we could remit the matter, ask them to fix a time and ask them to dispose it off.
Very well. Very well.
What time?
Maybe fixed by this one.
So how many weeks?
4 weeks.
The petitioner has called in question. But it can't be that whenever refund is made, refund is ordered, only then it pinches you, saying it's prejudicial in interest of revenue. Once that order is passed, that appellate order, is there a time for exercise of the revision power?
3 years. 3 years, my lord.
3 years. The petitioners called in question the correctness of the order at annexure AF, whereby the department in exercise of power under 108 subclause 1 of KGST/CGST Act has stayed the operation of the order in appeal GST AP 48/2223 dated 30/9/2023 passed by the Joint Commissioner of Commercial Taxes. Where is that order? Page?
That order is, my lord, at page number 85, annexure R.
in terms of the order passed by the Joint Commissioner of Commercial Taxes at Annexure R, the appeal filed by the petitioner came to be allowed. What is
Partly
the
allowed, my lord.
partly allowed? By modifying the order passed by the competent authority by confirming penalty under 129 within bracket 1A of the CGST Act 2017. Petitioner submits that subsequent to such order, petitioner sought for refund
Please, my
as
lord.
per annexure
Annexure S, my lord. This is the acknowledgement of my application, my lord. The application is at page number 113.
order.
Page,
There is an
please,
order
my
for
lord.
refund.
There is no order for refund. My refund application is pending even after 3 years, my lord.
Yes. ಏನ್ ಬರ್ದಿದ್ದೀರಾ? Annexure, as evidenced by annexure S, and despite lapse of considerable time, no order has been passed, and instead order at annexure AF has been passed without notice to the petitioner, and even subsequent to the order at annexure AF, no notice was issued.
No notice was issued to me for hearing, my lord.
The HCGP submits that the revision petition would be disposed of as per law.
As in accordance with law.
In accordance with law. Accordingly, the petition is disposed of.
But actually, notice is issued, my lord. They will send email, through email. They have not seen, my lord.
Let us see that. The proceedings before the revisional authority in what is the proceedings number? Revision proceedings. What is the reference? Some case number or what? What is that?
My lord, there is an order number at page number 138. SMR-1/GST/BNG/stays.
The proceedings relating to the revision filed against the appeal of the Joint Commissioner. Everyday order number, page 138. So and so is directed to be disposed of by the respondent number.
It's before, my lord.
Who's the revisional authority?
My lord, the revisional authority would be respondent number 7, my lord.
By respondent number 7.
Additional commissioner. Please, my lord.
Within a period of 4 weeks from date of receipt of certified copy of the order, all contentions are kept open.
All contention kept open.
Please, my lord.
Reconsideration.
Please, my lord. My lord, if I may also point out that I had also challenged the original order and there has been a replication of the first appellate authority order. I'll avail my remedies against those orders, my lord, in accordance with law, if those may be kept open.
No, no, my lord. Once all contention kept open means not required to observation of a particular.
No, now you are
Very well, my lord. There is only replication of the order that was also challenged only on account of the principle of res judicata. The first appellate authority maybe has overlooked, my lords. They have again passed an order subsequent to all of this happening, stating that my appeal is rejected. That order I'll have to challenge before the tribunal, my lord.
Which order? Annexure?
Please, my lord. This annexure X, my lord, page 121.
Now, this has nothing to do with the revision proceedings.
No, nothing to do with the revision, my lord. The only problem was that this was a replication of the order that has been passed.
Petitioner submits that they would not press for the relief at annexure X as regards the order at annexure X. Well, and all contentions may be kept open in light of the
Grateful, my lord. Grateful.
The contention, the annexure X is kept open to be raised before appropriate authority.
My lord, my in contravention HCP, that notice is issued, they are well aware, despite they have not appeared.
Counsel for HCGP submits that the contention of non-receipt of notice may not be appropriate As normally notice would be sent through email.
Yes, ma'am. Much.
Great.
Bill number 5, Harish.
May I please, Your Lordship? The matter was argued before my Lord extensively a couple of weeks ago relating to the constitutional virus challenge to the levy of service tax on ocean freight.
Ready, Jimmy.
Please.
I'll pass over and take it, or we can finish it.
All right, it is, in principle, it is covered. But however, my lord, SLP filed by the revenue is pending. But on the very same issue, in the GST regime, my lord, has already been decided by the Honorable Apex Court.
Holding the levy
Holding
to be
that, my lord,
unconstitutional.
levy is unconstitutional. That notification has been quashed.
Okay, so point out.
That is a, my lord, levy of a service tax on ocean freight in this case. In the next case, that is also listed. That is, my lord, IGST on ocean freight.
Yes.
So that nomenclature of this thing has changed, but the nature of the levy remains the same. My lord.
Yes, what is it?
Lordship, the synopsis was submitted on the earlier occasion. Colleague had submitted the notifications that are under challenge, Your Lordship.
Yeah, 30, na? 30 per 12, wa? Huh?
19754.
Yes, Lordship.
So take me through your synopsis.
30.
This is one.
He has filed index of compilation, case laws, then one synopsis.
Yes.
Actually, the challenge is to the notifications 15 and 16. Insofar as it makes the importer the recipient of service and passing on the burden to pay the service tax as a recipient on reverse charge. 15 defines the person as the recipient, and notification 16 creates the valuation.
Section 66. Now section of the reverse charge, 66.
66A.
A. Or these notification under section 66A of the, my lord, the Finance Act, where, my lord, normally a service provider is liable to discharge the service tax.
On provision of, onward provision of service law.
On provision of a service. But by virtue of this section, legislature is empowered to, my lord, to fix the liability even on the service receiver.
By these notifications.
By virtue of these notifications.
So the parent
by
section
exercise
is
of a
section
power under section 66A of the Finance Act.
66A read with section 68, Your Lordship. 68, section 68 of the Finance Act is the levy section.
Just take me through those provisions. Put. No, that has been omitted, is it? 66A.
No, it is
66A was there, Your Lordship,
there.
prior to 17/2012. That is the empowering section to make the recipient in India liable to service tax on receipt of services from outside India. That was the section that was introduced. Because prior to the introduction of section 66A, Your Lordship, there was no section that levied or made the recipient discharge the burden of the tax. So this was the dispute, Your Lordship, prior to the introduction of section 66A. Now, this was thereafter changed to 68(2).
Yes. Yes.
I'll just read the section, Your Lordship. If I could request my Lord's attention to the compilation that I had supplied,
Same.
which contains Messrs. Sal Steel, Your Lordship, serial number 5.
Yes. Yes.
Lordship, the relevant
CIF contractor.
all CIF.
All are safe.
All, there's no FOB.
FOB law.
There's no FOB.
Are you sure?
Yes, yes. There is no FOB in this case. All CIF contracts.
Because if it is FOB, it doesn't apply.
Yes. Your Lordship, this is a case where if my Lord would recollect, all imports are done on CIF basis, which is cost, insurance, and freight. This, the cost of the goods, insurance taken, and the freight is all included in the value when the goods are received in India on import. The importer discharges the applicable customs duty
on this value
and the applicable countervailing duty, because at that point in time, Your Lordship, in 2014, 15, 16, because prior to the GST, you had the countervailing duty imposed under Section 3 of the Customs Tariff Act.
Yes.
So the freight component, which is essentially the subject matter of dispute under service tax, was already subjected to levy of countervailing duty under the Customs Tariff Act. So the submission was that the ocean freight is essentially a consideration that the shipping liner negotiates with the exporter located outside India. And that consideration or that contract for shipping is a transaction between the exporter outside India and the shipping line located outside India. There is no privity of contract insofar as this freight cost is concerned. So therefore, the deeming fiction that creates the recipient as the importer, the Gujarat High Court in Sal Steel said that there was no basis or section which creates a deeming fiction that the recipient becomes the importer. And secondly, Your Lordship, the High Court also held that because the cost, insurance, and freight is a component of the customs duty, it cannot be again taxed as an aspect of service for the purpose of reverse charge levy under the erstwhile provisions of Chapter 5 of the Finance Act. So therefore, on these two grounds, the notifications, namely notification 15, which deems the recipient as the importer, and 16, notification 16 of 2017, which creates a value of 1.4% as the freight cost, as unconstitutional and ultra vires of the main provision.
Paragraph.
Lordship, the
now this judgment would hold good. Para.
My lord can say that, my lord, the issue is covered by this judgment. Revenue is unable to dispute it and can dispose it off.
Now that principle of kusum ingots applies to all this.
Applies to all, though it is issues pending before Supreme Court in SLP. No order has been passed, no stay has been granted so far.
So where is the reasoning at para?
Lordship, the page 70, if I could request my lord's attention.
Yes.
Paragraph 22 and 23, if I may be permitted to read first, and thereafter I'll take my lords to the specific paragraph which has held the notifications to be ultra vires of the rule making power. Paragraph 22, identical line of facts, Your Lordship. In the case on hand, indisputably, the overseas sellers, suppliers of the goods have made contracts with the shipping line for sea transportation of the goods. And such overseas sellers, suppliers have made payment of transportation charges to the shipping line. And admittedly, there is no contract nor any arrangement between the petitioners, who are the Indian importers, buyers of the goods, and the shipping line for sea transportation. Thus, ocean freight is admittedly paid by the overseas supplier sellers to the shipping line, and therefore the overseas suppliers, that is the sellers of the goods located in foreign country, are the persons who have received the service of sea transportation from the shipping line. And the value of such service, that is ocean freight, is also paid by such overseas suppliers for receiving such service. Next paragraph, Your Lordship. Ocean freight is the colloquial expression, but the service for which service tax is proposed to be collected under the impugned provisions is described as the transportation of goods by a vessel from a place outside India up to the customs station of clearance in India. In all the impugned note provisions under Rule 21D EEC of Service Tax Rules, Rule 6 bracket 7 capital CA of Service Tax Rules on, and also in explanation 5 of Reverse Charge Notification 30 of 2012, the service for which tax is proposed to be collected under the impugned notifications is thus admittedly rendered and consumed outside India, because the service is that of transportation of goods by a vessel from a place outside India up to the customs station of clearance in India. Then if I could request my Lord's attention to paragraph 25. Thus, the service proposed to be taxed under the impugned provisions is admittedly that of transportation of goods up to the Indian port, that is land mass of the country, and this service covering sea transportation of hundreds or thousands of kilometers is an event occurring beyond the land mass of the country, and hence in the nature of an extraterritorial event. The provisions of the Finance Act, which is an act of the Parliament for levy of service tax, do not permit nor empower the central government to collect service tax on such extraterritorial events and the services which are rendered and consumed beyond the landmass of the country. Statutory provisions. Thereafter, Your Lordship, paragraph 30. All the three impugned provisions are made by the central government by way of amending service tax rules. But there is no power conferred, this is important, Your Lordship, upon the central government under section 94 of the Finance Act for charging and collecting tax on extraterritorial events. The impugned provisions allowing the central government to recover service tax on sea transportation occurring up to the landmass of the country are therefore ultra vires the rule-making power of section 94 of the Finance Act. A perusal of section 94 shows that there is no power conferred upon the central government to make rules, any rules or notifications for extraterritorial events, or in other words, for services rendered and consumed beyond the taxable territory, that is beyond India. Obviously, the Act itself is not applicable to the territories other than India, and therefore executives cannot have any power to make rules for territories beyond India. The impugned provisions, paragraph 33, Your Lordship. The impugned provisions are also ultra vires the rule-making power of section 94 of the Finance Act. That is one aspect that they have referred to. The next one, Your Lordship. As observed above, 34. The person receiving service of sea transportation in CIF contracts is the seller supplier of goods located in a foreign territory. The Indian importers, like the writ applicants, are not the persons receiving the sea transportation service because they receive the goods contracted by them, and they do not have privity of contract with the shipping line, nor does the Indian importer make any payment of ocean freight to the service provider. But the impugned provisions make such importer liable to pay service tax, and therefore such provisions allowing the central government to recover service tax from a third party are ultra vires the statutory provisions of the Finance Act as discussed below. Paragraph 35, Your Lordship, if my Lord could recollect, I mentioned that 66B is the charging section. The charging section 66B provides for levy of service tax on the value of tax services other than those specified in the negative list. The term service is defined under section 65B 44 to mean any activity carried out by a person for another for consideration. Thus, service is an activity carried out by a person, that is a service provider, for another person, that is receiver of service. Only two parties are recognized by the Parliament in regard to service vis-a-vis the service provider and the service recipient and the recipient of service. Section 68A of the Finance Act lays down that every person providing taxable service to another person shall pay service tax, and thus the primary obligation to pay service tax is on the person providing such service. By virtue of subsection 2 of section 68, the central government has power to shift the liability to pay service tax. The method, which is popularly known as reverse charge mechanism, under which service tax is collected from the recipient of service. Notification 30 of 2012 issued under section 65(2) of the Finance Act is for reverse charge system, and the taxable must be service, your lordship, taxable service under para 2 of the notification shows that the central government has shifted the burden to pay service tax to the person receiving the service by virtue of column number 4 of the table. Thus, the reverse charge system under section 68(2) of the Finance Act permits the central government to collect and or recover service tax from the receiver of service, though the primary charge is on the person providing taxable service by virtue of subsection 1 of section 68. But the importers in CIF contracts, that is writ applicants herein, are neither service providers nor service receivers in India in respect of transportation of goods by a vessel from a place outside India up to the customs station of clearance in India. Section 68(1) and also the reverse charge notification under 68(2) permits the central government to collect and recover service tax only from the person providing the service or from the person receiving the service, and not from a third party. The rule-making power of section 94 also does not permit the central government to make rules for recovering service tax from a third party who is neither the service provider nor the service receiver. Therefore, the impugned provisions, that is Rule 21D EEC, Explanation 5 to Notification 30 of 2012, are ultra vires Section 65B 44 defining service, and Section 68 and also Section 94 of the Finance Act. So this is the second aspect, Your Lordship.
Now this has been taken up before the Apex Court.
Yes, Your Lordship.
No stay.
No stay has been granted. Thereafter, Your Lordship, the Bombay High Court, the serial number 1 in my compilation, had an occasion to deal with this issue, which is starting from serial number, page number 1, Your Lordship. The division bench of the Bombay High Court also dealt with the same issue. Subsequently, they made a reference to Sal Steel, and also interestingly, Your Lordship, what has happened is the CESTAT, that is the Appellate Tribunal for Service Tax in Ahmedabad, because they are bound by the jurisdictional High Court of Gujarat in Sal Steel, applied the decision of Sal Steel to say that the levy of service tax on ocean freight under service tax was unconstitutional. Now, interestingly, Your Lordship,
but now we could only say notification set aside on the broad principle of Kusum in gods. It's applicable extraterritorially. SLP no stay and leave it at that.
Yes, Your Lordship. Because they have paid the tax amounts under protest, Your Lordship, because the refunds may be sanctioned accordingly, because it's the levies has been held unconstitutional.
My lord, this issue, only one, my lord, clarification, applies to a contracts under CIF arrangement.
Only.
There is another, my lord, nature of another kind of a contract, my lord, BOE, FOB, free on board. So that your lords may make it, because other judgments do not deal with this, lord. That's.
So in Bombay, what did they say regarding refund?
Sanatan Textile.
Lordship, page number 9.
Yes.
Petitioner, point number 2, Your Lordship.
My
the
lord,
petitioner would accordingly be entitled to the refund of duty. However, subject to the petitioner filing the refund application, which would be required to be decided in accordance with law, including on the principles of unjust enrichment.
This observation, my lord.
Because Justice, Your Lordship, the Supreme Court Constitutional Bench in Mafatlal, when they declared the law with respect to refund on an unconstitutional levy, they said while the time limit may not apply, the principles of unjust enrichment will definitely apply. The same language could be used.
If the duty burden is already passed on
Yes, Your Lordship.
to a consumer of the petitioner,
Then I will
then,
not be
my lord,
entitled to cash
he may
refund.
not be entitled for a
Cash
refund.
refund. It will go to the consumer welfare fund, Your Lordship.
That's
the petitioner. Now there are two matters, is it?
no, only one matter, my
only
lord.
one, only
The next matter also is similar, but that is in the GST regime.
Let us, the petitioner has called in question the validity of the notification 15 of 2017-ST and 16 of 2017-ST dated April 13, 2017 on various grounds, including that the said notifications lack legislative competency and ultra vires the Finance Act 1994. Consequently, the petitioner has sought for setting aside of the demand notice.
Yes.
At annexure F1. Petitioner has also, the petitioner at the time of arguments has submitted that the amount already collected pursuant to proceedings conducted in connection with the notification of annexure A and B are required to be refunded. Full stop. It is the case of the petitioner that he is a manufacturer in India and makes imports on cost, insurance and freight basis. Full stop. It is further submitted that the foreign supplier bears the cost of freight for the transportation of goods till the port in India. The petitioner, it is stated, pays the custom duty on the entire value of cost, insurance and freight. Full stop. Next, it is further specifically a word that is the foreign supplier who engages a foreign transporter and petitioner is not involved in this arrangement and the services of the transporter is availed by the foreign supplier. It is accordingly submitted that the service being availed by the foreign transporter, the question of levying any tax by virtue of the notification impugned does not arise. Full stop. Insofar as the factual aspect as asserted, the revenue does not controvert such aspects. Full stop. Petitioner submits that the identical issue had been the subject matter of adjudication before the Gujarat High Court in the case of Messrs. Sal Steel Limited and one other versus Union of India 2020 volume 37 within bracket GSTL 3 Gujarat. Full stop. It is submitted that the Gujarat High Court has already adjudicated on such issue by order passed by a division bench in the above mentioned matter and the present petition also be disposed of on same terms. Learned Counsel Jeevan appearing for the respondent submits that the said order of the Division Bench of the Gujarat High Court is pending in a SLP filed before the Apex Court, though as on date, the order of the Gujarat High Court has not been stayed. Full stop. It is in light of admitted facts, including as regards the assertion that the petitioner is importing on cost insurance and freight basis, which is in contradistinction to FOB contracts. The observations of the Gujarat High Court made in the context of CIF striking down the impugned notifications would be applicable. Full stop. The observations made by the Gujarat High Court in the case of Sal Steels at para 22, 23, 25, 31, 33, 34, 35, 36 reads as and 38 reads as follows. Also, the Gujarat High Court has clearly expressed the view on two aspects, that the Act itself would be inapplicable to territories other than India, and the executive would not have the power to make rules for territories beyond India, and where the events could be described to be extraterritorial events, that is, service provided by a foreign exporter and a transport company which also is enters into contract for transportation outside the territory of India. Such extraterritorial transactions cannot be subject matter of a national law. Full stop. The other aspect that also becomes clear is that the charging section under section 66B provides for levy of tax on value of services other than those specified in the negative list. Full stop. Thus, service is an activity that is taxable, and the two parties who are availing of service is the foreign exporter and the transporter, while the importer in a CIF contract does not avail of any service of transportation. If that were to be so, the said aspect is also covered as per the observation made at para 38 of the judgment of the Gujarat High Court. We'll stop. Next. In light of the same, this court is in agreement with the above legal position, while clarifying that the validity of notification is in the context of CIF contracts only. Full stop. In light of absence of any stay of such order, and in keeping with the principles of Kusum Ingots and Alloys Limited versus Union of India 2004 168 within bracket ELT 3 SC, the validity of notification having been adjudicated in terms of Article 226(2), the same would be the legal consequence throughout the territory. Accordingly, in the present case as well, taking note of the judgment of the Gujarat High Court, the relief granted therein is reiterated. Notification at Annexure A and B are set aside, noticing the are declared illegal, noticing it being set aside by the Gujarat High Court. Insofar as the contention insofar as the contention relating to refund as regards duty service tax paid under protest in light of setting aside of notification at annexure A and B in terms of the principle of unjust enrichment, petitioner is entitled for refund, subject, however, to petitioner making
Lordship, Annexure F is the demand notice. Annexure F is the demand notice.
just one petitioner to file application for refund, which is to be decided.
File a refund application.
Petitioner to file application for refund, which is required to be decided in accordance with law on the principles applicable, including that of unjust enrichment. Now, demand notice you want to be set aside.
Yes, Lordship. Annexure F, Your Lordship.
In light of the
demand notice in pursuance of that demand notice only he has discharged the service tax, which your lordships have directed for a refund. Now,
one paragraph
to set aside
the consequent to setting aside of the notification at annexure A and B, the demand notice at annexure
F, Your Lordship.
F is set aside of the mailer.
I'm grateful, Your Lordship. Much obliged.
Serial number 6, M. Prakash, party
What is this matter?
My lord, this is also a similar issue. Ocean freight in the GST provisions. Now the IGST was sought to be imposed on this ocean freight paid under CIF contract. Honorable Apex Court, my lord, has held that, my lord, it is an illegal.
Where is that?
And set, my lord, that a court of and whether it is CIF contract. Nimdu CIF contract. CIF tane. Huh? CIF only. That's what. My lord, 69 you lost. Page number 69 of that judgment, the ink page. Yes. Last page. My lords may go to last page. That Roman 5.
Yes.
That's the impugned levy imposed on the service aspect of the transaction is a violation of the principle of composite supply. So and so, since the Indian importer is liable to pay IGST on the composite supply, comprising of supply of goods, supply of services of transportation. This is a CIF contract. Insurance, etc. in a CIF contract. A separate levy on the Indian importer for the supply of services by the shipping line would be in violation of Section 8.
What is Section 8?
My lord, Section 8, my lord, it is the 7 is the supply. Section 8.
At page 19, my lord.
Right.
It's on composite supply.
Composite supply. It defines composite supply. Composite and mixed supply.
So since it is
composite supply,
since it has already suffered tax,
yes, under composite supply
by virtue of the shipping line.
Yes, yes.
Huh?
Yes. Well, in the composite supply, my lord, the principal supply will be taxed.
So the principal supply is that of the transportation
Lord,
to the shipping line. Shipping line.
That is, my lord, the supply of
services.
Service.
No, no, composite supply, the principal supply would be, my lord, the supply of goods. which attract an import duty.
So in that they include both
They
components.
included all this, my lord. See, contract, my lord, this thing, in insurance and freight are already included that, the valuation.
So
So IGST is imposed on both on this interstate transaction. The valuation is on CIF value.
which paragraph?
My lord, that
Which paragraph of Mohit Minerals?
So it is in
Mohit Minerals.
paragraph 148 in page number 148.
No.
69. Para 148.
No, sir. That is a conclusion.
Ah.
That is a discussion.
Para 113, just see. Para 113.
My lord, I just. Yes.
Or where is the conclusion, Vince?
My lord, I'll just. My lord, 142 onwards, you will also make analysis.
142
paragraph at page 66. The reasoning of the, my lord, the court.
Just read.
Please.
Just read.
I'll read. In the present case, the question is whether the imposition of IGST on supply of services can be sustained when there is a concomitant imposition of IGST on supply of goods. However, we must first analyze the context in which the IGST is levied on the import of goods in this case. The provisions of composite supply in the CGST Act and the IGST Act play a specific role in the levy of GST. The idea of introducing a composite supply was to ensure that various elements of transportation are not dissected and the levy is imposed on the bundle of supplies altogether. This finds specific mention in the illustration provided under section 2, subsection 30 of the CGST Act, where the principal supply is that of goods. Thus, the intent of the parliament was that a transaction which includes different aspects of supply of goods or services and which are naturally bundled together must be taxed as a composite supply. It is true that in this case, the first leg of the transaction between the foreign exporter and the Indian importer is a composite supply, while the second leg between the foreign exporter and the shipping line may, from a perspective, be regarded as a standalone transaction. Both of them are independent transactions, and ordinarily the IGST could be levied on both sets of transactions, one as supply of goods and the other as a supply of services. However, the impugn notifications seek to tax the importer as the deemed recipient of the supply of service. The ASG has advanced an interpretation of section 5354 of the IGST Act, read with section 293 of the CGST Act, to contend that the importer can be classified as a recipient of the services. On this interpretation, we have upheld the validity of the impugn notification under section 53 and 54 of the IGST Act in section so and so of this judgment. The respondents, as a matter of fact, urge that the Indian importer is not privy to the contract between the foreign exporter and the foreign shipping line. The Indian importer does not pay consideration to the foreign shipping line, and the Indian importer does not receive any services from the foreign shipping line, since the transportation services are provided by the foreign shipping line to the foreign exporter. The ASG, while advancing arguments on behalf of the Union government, has opposed these submissions. The Union government has urged that this court must look beyond the text of the contract between the foreign shipping line and the foreign exporter to identify the Indian importer as the recipient of the services. This court has upheld the validity of the impugn notifications on this ground. The Union government is contradicting the main plank of its submission now by contending that two legs of the transaction are separate standalone agreements. That would imply that while on the one hand, the Union government seeks to levy tax on the Indian importer by going beyond the text of the contract between the foreign shipping line and the foreign exporter, on the other hand, As far as the submissions of the composite supply are concerned, the Union government urges that the contract must be viewed as a separate transactions operating in silos. We are unable to subscribe to this view. The Union of India cannot be heard to urge arguments of convenience, treating the two legs of the transaction as connected when it seeks to identify the Indian importer as a recipient of services, while on the other hand, treating the two legs of the transaction as independent when it seeks to tide over the statutory provisions governing composite supply. This court is bound by the confines of the IGST and CGST Act to determine if this is a composite supply. It would not be permissible to ignore the text of Section 8 of the CGST Act and treat the two transactions as a standalone agreements. In a CIF contract, the supply of goods is accompanied by the supply of services of transportation and insurance, the responsibility for which lies on the seller. The supply of service of transportation by the foreign shipper forms a part of bundle of supplies between the foreign exporter and the Indian importer, on which the IGST is payable under Section 5(1) of the IGST Act, read with Section 20 of the IGST Act, Section 8 and Section 230 of the CGST Act. To levy the IGST on the supply of service component of the transaction would contradict the principle enshrined in Section 8 and be in violation of the scheme of the CGST legislation. Based on this reason, we are of the opinion that while the impugned notifications are validly issued under Section so and so, it would be in violation of Section 8 of the CGST Act and overall scheme of the GST legislation, as noted earlier. Under Section 73 of the CGST Act, 73 of the CGST Act, the central government has the power to notify the import of goods as an import of services and vice versa.
Para 147.
147.
And then the conclusion.
Then the conclusion. Here is in both the cases, in the previous case and this case, the foreign exporter who is exporting the goods engages the transporter. So the transporter located in a foreign territory supplies services to the foreign exporter. So that value of whatever is there, my lord, is included in the, my lord, as a CIF value.
But the emphasis here is more on composites.
This is emphasis on the composite supply.
So here, what are the facts now?
My lord, here also.
Here also.
He has imported under a CIF contract. And he being the recipient sought to be taxed by virtue of these notifications. Lost my here. The same notification entry. Ask him same notification.
Same notification?
Yeah, same. Lord,
County number is it notification?
no notification. You also my kindly see, Lord. Prayer.
Yes.
Direction passing the impugned serial number 9 plus 2 of notification 8/17 integrated tax. Then, my lord, notification 10 of 2017 integrated tax dated so and so. My lord, here also paragraph 6 of the Supreme Court judgment. My lord. I'm just saying, my lord, notifications.
Para
6 page number 7 of that.
Eight and 10.
6, my lord, para 6.
Correct.
8 and 10.
Huh?
That is the subject matter of.
So it's squarely covered.
Yes.
So what is the final relief now?
Now the final relief is, my lord, as far as CIF contracts are, you'll also kindly take to come to, my lord, page 69, Roman 5 of paragraph 148 it is.
So now what has to be set aside here?
My lord, this
Show,
Show cause notice at.
show cause notice
At
it's
annexure
still,
D, my lord.
it's still at that stage.
at the stage.
The annexure D,
Yes.
Yes.
the petitioner.
My lord, C.
Huh?
Impugned show cause notice dated 11/9/2020.
Yes.
Then, my lord, may kindly repeat this one, my lord. Paragraph 6, paragraph that subpara 5, Roman 5 at page 69. That is the conclusion. In view of that, my lord, this can go. All consequential proceedings.
The petitioner is sought for setting aside of the notification at serial number 9.
Huh. That is, my lord, serial number 9, clause 2 of notification 8/2017.
Serial number 9, clause 2 of notification number 8 of 2017 dash integrated tax dated 28/6/2017 at annexure A, as well as the corrigendum notification dated 30th June 2017 at annexure B, and serial number 10
of the notification.
Notification number 10/2017 dash integrated tax dated 28/6/2017 at annexure C, issued by respondent number 1, by declaring that the same are ultra vires to IGST Act 2017 and unconstitutional. The facts made out are that the petitioner, you are an importer.
I'm an importer.
Is an importer
of what?
Of various commodities.
He has not said it, so what he imports.
Is an importer and has called in question the levy on the basis of reverse charge mechanism by virtue of the impugned notifications. Good stuff. Petitioner submits that the identical legal issue has already been adjudicated upon.
Yes.
And decided.
The case of Mohit Minerals.
In the case of Union of India versus Mohit Minerals 2022 within bracket 61 GSTL 257 SC within bracket 19522, and in light of the notifications impugned herein already having been challenged, already having been set aside by the apex court, petition may be allowed. The legal position, next, the legal position is not controverted by the other side. Full stop. Taking note of the observation made by the apex court in Mohit Minerals at para 147 and 148, it would be appropriate to dispose of the petition. Para 147 as well as para 148. 148, only that portion is.
Portion, yes.
Huh?
Yes.
Para
Roman 5.
148. Based on the above discussion, we have reached the following conclusion. Okay, dot 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 Roman 5. Next. They set aside both the notifications.
Yes, yes. paragraph
full conclusion.
6.
Para?
Para 6 your lordships में that's notifications are reflected.
It is to be noticed.
Page number 7, para 6 of that judgment.
That the subject matter of the dispute
Yes.
before the apex court is encapsulated in para 6, which reads as follows. Eventually, the apex court has upheld the order of the High Court and proceeded to set aside attempts to levy this tax were already the same is the subject matter of composite supply.
Composites.
Next, accordingly, in the present case as well, in light of the law laid down by the apex court and setting aside of the notification, the impugned notifications already having been adjudicated upon as observed above, the show cause notice at annexure D is set aside. Yes. And the proceedings initiated would die a natural death. Yes.
Seven, Venkatesh Kumar is.
Very short issue, my lord. It's covered by the circular. Basically, the issue is that whether a recipient of goods will be required to reverse the ITC attributability discount issued by commercial through commercial credit note by my supplier. My supplier is Ultratech Cements, my lords. I am the recipient of goods.
You are
circular is there. It's directly on this point actually. And this entire circular they omitted to consider because I have given my submission also. A reply page number. My reply page number in page number 42, my lords. Show cause notice reply page number 42 in page number.
Round ನೋಡ್ಬಿಟ್ರೆ
One ನಿಮಿಷ ಹೇಳ್ಬಿಡ್ತೀನಿ ಅಷ್ಟೇ ಒಂದೇ ನಿಮಿಷ.
I don't know my lord.
In page number 42 ನಲ್ಲಿ 42 para number 9, my lords.
Page
42
para number 9
on client
circular ಇದೆ.
ಒಂದು ತಲೆ ಮೇಲೆ
Yes, yes, madam. ಈ ಸರ್ಕ್ಯುಲರ್ ಡೈರೆಕ್ಟ್ಲಿ ಬೇರಿಂಗ್ ಆದ ಈ ಇದರಲ್ಲಿ
ಹಾಕಿಲ್ಲ.
ನಾಟ್ ಇವನ್ ಒನ್ ಡಿಸ್ಕಷನ್ ಇಲ್ಲ madam. ಈ ಆರ್ಡರ್ ನೋಡಿದ್ರೆ
This is for a satisfaction of the client.
Jeevan is contending. Yes. Your grounds also is that.
ಇಲ್ಲ ಸಿ ಎಂಟೈರ್ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಎಂಟೈರ್ ಸಬ್ಮಿಷನ್ಸ್ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಅಂತ.
This is not pleaded in the ground.
Entirely, see, not only this, why I brought this circular, my lords, entire, there is entire discussion told. Putting already.
ನೀವು ಅಪೀಲ್ ಹಾಕಿ ಅಪೀಲ್ ಅಥಾರಿಟಿ ತೋರಿಸಬೇಕು. ಸುಮ್ಮನೆ ಅಲ್ಲ ಸುಮ್ಮನೆ.
First issue is this is the first issue, my lords. Para number 1, my lord, serial number 1. Whether the full ITC is available to the recipient of supply. I am recipient of supply, my lords. When the recipient makes a discounted payment to the supplier of goods on account of financial or commercial credit notes issued by said supplier. Clarification, my lords. Section 16(1) of CGST Act provides that every registered person shall be entitled to take credit of input tax charge on any supply of goods or services or both, which are used or intended to be used in the course or furtherance of business, my lords. It has been clarified by circular number 92. E circular, my lords, I have referred in my reply. 7th March 2019. ಇದು ಅದಾದ್ಮೇಲೆ ಮತ್ತೆ ಕೊಟ್ಟಿದ್ದಾರೆ ರೀಸೆಂಟ್ ಆಗಿ. That the supplier of goods can issue financial credit notes, commercial credit notes on, in such cases, he will not be eligible to reduce his original tax liability, as the transaction value is not allowed to be reduced on account of issuance of financial/commercial credit note. Accordingly, the tax charged from the recipient would also not get reduced. Thus, it is clarified that recipient will not be required to reverse the ITC attributed to the discount provided on the basis of commercial credit note issued by supplier, as there is no reduction in the original transaction value. Accordingly, the corresponding tax liability would also not get reduced.
So now what has happened?
ಇಲ್ಲಿ ಬಂದ್ರೆ Come to their discussion, page number 76, my lord, in page number 75, I'm sorry. This is the impugned order, my lord. Annexure
Next
C,
week
my
I'll
lords.
I'll get instructions on this.
One nimsham.
Because these are all not pleaded in the anywhere, my lord. First time my learner friend is making submissions on this.
I'll accommodate.
Yes, please.
Para, page?
Para, my lord, in page number 75, come to para number 20, my lord.
Yes.
Their discussion.
Yes.
I'll read it. Only one paragraph I'll read it. In respect of para number 1 of financial audit report as discussed above, white para number 3.1. 3.1 under issue, my lords. Show cause notice. Find that the taxpayer received discount from suppliers, reducing the actual payment for the goods. These discounts led to the excess ITC being claimed, as ITC was based on original higher invoice value, not accounting for the discounts. The net effect of these discounts resulted in lesser payment being made with the taxpayer for the value of supplies. To the extent of the amount received, as discount, as per the provision of 15(3) pertaining to valuation and section 16(2) pertaining to ITC, read with rule 37, the taxpayer was entitled to avail the credit of ITC only to the extent of amount of payment made by them towards the value of supply and proportionate amount ITC. However, in the present case, the taxpayer has availed ITC based on original invoice amount. Hence, I find that the excess ITC claimed in respect of the discounted amounts required to be reversed and the value of short paid is to be recovered from the supplier, from the taxpayer as per provision of section 74.
Let him find out. Now it appears covered.
Idralli,
No, correct.
yes. Yellow discussion illa.
Well, counsel for the petitioner submits that the aspect stands covered by the circular dated 12th September 2025 for say of the revenue. This is the matter in the preliminary hearing stage on next Tuesday.
Please.
Yes.
ಅದಕ್ಕೆ ಬೇರೆ ರಿಕವರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಬೇರೆ ಇನಿಷಿಯೇಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಹೌದು, ಅದಕ್ಕೆ ಹೋಗಿ ಲೆಟರ್ ಬರೆದು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿ ಇಷ್ಟೊಂದೆಲ್ಲ ಡಿಸ್ಕಷನ್ ಎಲ್ಲ ಮಾಡಿದ್ರೆ ಏನೂ ಇಲ್ಲ, ಇನಿಷಿಯೇಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಕೂತ್ಕೊಂಡಿದ್ದಾರೆ.
We'll dispose it of next.
Yes, my lord. Much obliged.
8 DP Mahesh.
Pertaining to bearer to posted on 16/2.
List on
16/2.
Yes.
And serial number 19 also.
19.
Yes, it is also PRR 1. MS Rajendra.
We have adjourned it only.
16/2. Please.
At the date could be.
Mission 9. Rule the receipt.
Petitioner's counsel. My lord, you extend the synopsis today, you are not required to file it. File it in the counter. I request for a date next week. Well, there is some urgency that we are pleading, which is why your lordship fixed it today.
Correct, eh?
No, you have argued on jurisdiction, sir. They asked me to, the court asked my response. There is some urgency as far as we are concerned. Of course, they will be happy to have it next week. Lordships may kindly peruse the order passed on the last day. The direction was in fact to both of us to file the synopsis. We will exchange that synopsis today. All I'm saying is I'll file it in the counter. Lordships will fix a date next week, we'll argue. Because if your lordships recollect. Also have the benefit of responding to the synopsis that they have served on me now. So therefore, all I'm requesting is for next week.
So,
Okay, so what we could do, I will accommodate you. For some time, if it's not going to take much, now we were on that aspect of the jurisdiction. So let him finish on that. And then I will give you an opportunity for you to take your stand regarding what he has raised. You have filed your synopsis. You are required. They have filed, is it?
We also filed. I think we have served, we have exchanged with each other. I think court may not have a copy, my lords. I'm just passing on my synopsis and the list of authorities. Yes.
Synopsis, written submissions filed by the petitioner as well as written synopsis of arguments filed by the respondent along with memo of citations is taken on record. Now it is their contention that the clause
Yes, Lord.
Would have the effect of exclusion
Yes, Lord.
of jurisdiction, and in terms of the law without reference to principles of civil law.
Yes,
That appears to be the essence of.
That is their submission, my lord. Their submission in naturally your lordships captured it correctly. What they're saying is the venue is mentioned. The agreement mentions the venue. Venue becomes seat. Seat excludes everything else. That's their essential contention. Venue is mentioned in Mumbai. Therefore, Mumbai is seat, and therefore courts in Mumbai should have jurisdiction. That's the sum and substance of their argument.
Yes.
Well, my submission was threefold. One, we are dealing with international arbitration, international commercial arbitration, not domestic arbitration. That's the first point. And there's it has an impact on how your lordship looks at the clause. That's the first point. Second point, my lords, even otherwise, what courts have distinguished, this venue becomes seat principle. There's a Supreme Court judgment and then subsequent judgments by the Delhi High Court and the Calcutta High Court, which point out that when venue may be considered seat, but for other reliefs, if the parties have indicated, the phrase used, by the courts is contrary indicia. If there are other clauses in the agreement which indicate the parties have chosen a regime which differs from venue equals seat, therefore to the exclusion of every other court, then, my lords, courts have to look at the contract in a holistic manner, the clause in a holistic manner, and give full meaning, effect and meaning to the choice of the parties. That, my lords, is the principle. It is more so in international arbitration, but even for domestic arbitration, this is the view, my lords, that courts have taken. So if, my lords, venue and seat by the language in the clause in case of domestic arbitration excludes every other court, then, my lords, there ends the matter as far as domestic arbitration is concerned. As far as international arbitration is concerned, venue and seat for certain things, yes, but for obtaining interim reliefs, the Supreme Court has said you can still approach courts in India, even if the venue and seat is outside India. That, I'll point out that judgment. Third, the impact of the clause, that is the specific language chosen by the parties, has to be given full effect too. These, my lords, are the three principles, my lords. All of it, my lords, linked to why, my lords, should the courts consider the clause in a holistic manner and give effect to? It's linked to party autonomy. That parties are choosing a particular regime, then courts have to give effect to party autonomy. And, my lord, some courts have used colorful language. They say courts should not commit violence on the language chosen by the parties. That's the, my lord's, language used by certain courts. But essentially, my lords, we should not render the clauses chosen by the parties redundant by reading in some exclusionary regime. That's the point, my lords, that the courts have made. Now, my lords, what I will do, my lords, we'll just straight away go, my lords, to the clause. Read the clause once, my lords, and then, if your lordships take my written submissions, I've extracted the clause there. On page 2, I've extracted the clause there, my lords. Clause 10.7. My lords, any dispute so and so, so and so, resolved by arbitration under the London Court of International Arbitration, India arbitration rules. My lords, at the last line on that page, my lords, the arbitration shall be considered an international arbitration, and on, my lords, that there is no dispute. My lords, and I would request your lordships to kindly underline the next 3 lines. And the parties waive rights to seek review of the award for errors of law or fact in any court. My lords, this is an unusual clause. As I'm reading this, my lords, because to point out that this clause is unusual in the sense that it creates a regime for itself as to how disputes should be resolved. The one thing they choose, my lords, is parties waive rights to seek review of the award for errors of law or fact in any court, provided, however, either party may seek judicial review for errors of law of any award of any injunctive or other equitable relief. Parties, my lords, have chosen that an award shall be final except in connection with some injunctive or equitable relief.
Correct, but that injunctive or equitable must be relating to the award.
To the award. I'm just pointing out, the reason I'm pointing out is the parties have chosen a particular kind of regime in this clause. So that your lordships have to keep that in mind. Next, my lords, is the arbitration should be conducted in the English language in Mumbai. This, my lords, is a venue. Now, my lords, if my learned friends were correct, venue equals seat, that matter should end there. But parties don't stop there. They, my lords, then go to, if your lordships come to, my lords, I on page 5. Page 5, my lords. They now choose, they now insert this. The award of the tribunal may be entered and enforced in any court of competent jurisdiction in Mumbai, India. My lords, if court venue equals seat equals exclusion to anything else, there was no need to mention this clause at all. Then, my lords, the next 10 point, my lords, J. Any party may seek emergency, interim, or provisional relief prior to mediation or appointment of a full arbitral tribunal from any court of competent jurisdiction without prejudice to this agreement or any ancillary agreement to mediate or arbitrate in accordance with section 10.6 or this section 10.7. After the appointment of a full arbitral tribunal, any request for such relief shall be addressed to the arbitral tribunal, which shall have the power to enter an interim award granting any emergency, interim, or provisional relief to which a party may be entitled under applicable law. So my respectful submission is this, that parties have chosen a regime of arbitration where they choose venue, and for enforcement, they specifically choose one court, enforcement of the award. For interim reliefs, they leave it open, saying you go to any court of competent jurisdiction. Well, this also is in line with general practice in international commercial arbitration. Well, because parties are in two different jurisdictions.
Correct. Now, in terms of the scheme of the Act.
Yes, Mullah.
What is the provision relating to interim relief, under the arbitration?
Well, now, after the amendment, section 2, for in international arbitration, now there is a specific proviso. Section 2, 2. My lords, your lordship have. This part shall apply where the place of arbitration is in India, provided that subject to an agreement to the contrary, the provisions of sections 9, which is the interim relief which we are concerned with.
Section 2.
Section 2, subclause 2, my lord. Section 2, subclause 2 proviso. Section 2, subclause 1 only, there are a lot of, A, B, C, D, E. So then after J, after 1J, 2 starts.
Yes.
This part shall apply where the place of arbitration is in India. The proviso is the exception. Provided that subject to an agreement to the contrary, the provisions of section 9, which is what we are concerned with, interim relief, 27 and clause so and so, shall also apply to international commercial arbitration, even if the place of arbitration is outside India. And this is what your lordship needs to underline. Even if the place of arbitration is outside India. Now, if my learned friends were correct, if there is a place of arbitration outside India, there ends the matter. That is their argument. That generally works in domestic arbitration subject to clauses. That's what the courts have said. In international arbitration, because assets of parties may be in different places, because the contract may have been performed in different places, certain kinds of relief have to be sought from particular courts. Because just to take our own example, if, my lords, now in international arbitration, what happens is even before the arbitral tribunal is constituted, sometimes a there's a practice now of what is called an emergency arbitrator. Before the tribunal is constituted, the institution may appoint an emergency arbitrator to give some interim relief. That emergency arbitrator's award, interim award, for example, is not enforceable directly as an award in India. So you have to come to the court, High Court, if it's an international commercial arbitration, if the assets that need to be protected are within the jurisdiction of the court. Just to give an example. So the Act recognizes that in international commercial arbitration, seat of an arbitration, even if it is outside India, does not mean the court's powers under Section 9 do not exist. And I need to go to the jurisdiction wherever the arbitration is being conducted for interim reliefs. For supervisory of the arbitration, that's a separate thing. But interim reliefs, my lords, are what is called supportive jurisdiction. It supports the arbitration. It doesn't supervise the arbitration. For supervisory jurisdiction, yes, you have to go to the courts where the seat is being, where the arbitration is being conducted. But for supportive jurisdiction, we have to go according to the Act. And there's a specific exception carved. No, my lords, I'll just continue, my lords, with my written submission itself, because I've framed the argument there, my lords. If your lordships go to para 6 on page 6, my lords, the expression emergency, interim or provisional relief, that's, my lords, the language in 10.7J of the agreement.
No, but you're saying Section 9, which otherwise you would have to go to the same court.
My lords,
Section
yes.
9.
Yes.
There's an exception here.
Yes. My lords, Section 9, if, my lords, the arbitration was outside India, if 2.2 exception was not there, you could not even come to Indian courts for interim relief. If the exception to, if the proviso to 2.2 was not there. Now, my lords, the peculiarity in this case, the reason why my learned friends are urging this seat venue equals seat and therefore Mumbai only has jurisdiction is, here is a case where the international arbitration venue is in India, in a city other than Bangalore. Now, if venue was Singapore or Hong Kong or London, even then this court would have had jurisdiction because of the exception to Section 2.2 and because of what is written in the contract. And this is, my lords, what the Supreme Court has held. A 3-judge bench, my lords, I have cited that, my lords. I'll just read this paragraph and come to the Supreme Court judgment. So this expression emergency, interim or provisional relief assumes particular significance as it demonstrates.
Reading at
Para 6, my lords, of my written submissions. I just want your lordships to, I want to stress, my lords, just the last line, my lords, last sentence in that para 6. The clause that your lordship is considering acquires a unique and peculiar character as it envisages the operation of two separate jurisdictions for two distinct stages or procedures within the arbitral process. Because we have specifically chosen Mumbai for enforcement of the award. Specifically chosen. And for interim relief, we have left it any court of competent jurisdiction. Well, it's logical also, because we don't know when we write the contract, who is the party seeking the interim relief. Well, if my learned friends were in my shoes today, if they were coming under Section 9, they would have to come here, because I am located here. And my argument is the contract was performed here, my lords. I'll come to that later. Therefore, my lords, it is left open. It is always left open because we don't know who is going to go to arbitration and who is going to seek interim relief and of what nature. Therefore, it is important that all courts of competent jurisdiction have ability to give interim relief. Otherwise, it may be that the arbitration itself is frustrated by some assets being siphoned off or some other action being taken by one of the parties. Now, my lords, I will go directly, my lords, to the Supreme Court judgment. My lords, if your lordships take my case compilation, it is the first case, my lords. Well, it's Mankastu Impex versus Air Visual. Limited, a three-judge bench of the Supreme Court. Now, your lordships come to page number, my lords, at para, my lords, 17. Para 17, page number 7. If your lordships come to page number 7, yes. My lords, I have extracted, my lords, the clause, the arbitral clause that they were dealing with. The lordship has that, yes. Governing law and dispute resolution. This MOU is governed by the laws of India without regard to its conflict of law provisions, and courts at New Delhi shall have the jurisdiction. Then, my lords, immediately the next clause, the clause says, any dispute, controversy, difference, or claim arising out of or relating to this MOU, including the existence so and so, arising out of or relating to it, shall be referred to and finally resolved by the arbitration administered in Hong Kong. Then 17.3 on the next page. It is agreed that a party may seek provisional, injunctive, or equitable remedies, including but not limited to preliminary injunctive relief, from a court having jurisdiction before, during, or after the pendency of the proceeding. Well, the question before the Supreme Court was, when Hong Kong is mentioned as a place of arbitration, and also there's a clause saying administered in Hong Kong, could the Supreme Court under section 11 appoint the arbitrators? Well, the Supreme Court said this, fellows. They said that the place and the administration of the arbitration is Hong Kong, so we won't exercise section 11 jurisdiction. However, the clause has to be read as a whole, and for interim reliefs, you have to come to Delhi. Fellows, I'll read that paragraph, fellows. Fellows, if your lordships come to page 10, paras 26. Fellows, I'll read from 25, my lords, page 10.
Just 1 minute.
Yes.
Yes, page.
Page number 10, para 25. 25. Clause 17.1 stipulates that MOU is governed by laws of India and courts at New Delhi shall have jurisdiction. Interpretation to clause 17.1 shows that substantive law governing the substantive contract are the laws of India. The words in clause 17.1, without regard to its conflict of laws provision and courts at New Delhi shall have jurisdiction, has to be read along with clause 17.3 of the agreement. As per clause 17.3, the parties have agreed that the party may seek provisional, injunctive, or equitable remedies from a court having jurisdiction before, during, or after the pendency of any arbitral proceedings. In Balco, this court held that on a logical and schematic construction of the Arbitration Act, the Indian courts do not have the power to grant interim measures when the seat of arbitration is outside India. If the arbitration agreement is found to have seat of arbitration outside India, then the Indian courts cannot exercise supervisory jurisdiction over the award or pass interim orders. It would have therefore been necessary for the parties to incorporate clause 17.3 that parties have agreed that a party may seek interim relief for which the Delhi courts would have jurisdiction. Plus, Balco, of course, was before the proviso was brought into force in 2.2. That's why, my lords, that confusion existed at that time. Then now the legislature has clarified. Now, my lords, next, my lords, I'll skip, my lords, 26, where they say that Section 11 has no application to where international commercial arbitrations is seated outside India. I'll read my lords para 27. The words in clause 17.1, without regard to its conflict of laws, provisions, and courts at New Delhi shall have the jurisdiction, do not take away or dilute the intention of the parties in clause 17.2 that the arbitration be administered in Hong Kong. The words in clause 17.1 do not suggest that the seat of arbitration is in New Delhi. Since part 1 is not applicable to international commercial arbitrations, in order to enable the parties to avail the interim relief, clause 17.3 appears to have been added. The words without regard to its conflict of laws, provisions, and courts at New Delhi shall have the jurisdiction in clause 17.1 is to be read in conjunction with clause 17.3. Since the arbitration is seated at Hong Kong, the petition filed by the petitioner under section 11(6) of the Act is not maintainable and the petition is liable to be dismissed. Now, my lords, our agreement is also dated 2014. So we had to include that interim relief we can come to Indian courts. Otherwise, Balco would have applied and would not have been able to approach the Indian courts.
Right, but the only difference appears to be, in this case, the seat was outside.
Outside.
But here the seat is.
The seat is in India. Yes. But it is an international commercial arbitration. Now, my lords, what courts now have interpreted, my lords, if there is an express or implied choice that for certain things, certain courts, you have to go to certain courts, you have to go to those courts, even in case of domestic arbitration. Even when that court may not have jurisdiction. But where the parties are very clear that they have a differentiated regime, that is, for certain things you go to certain courts and for certain other things you can go to other courts as the courts may have jurisdiction, then courts should not do, my lords, in the words, my lords, of both the Delhi High Court and the Calcutta High Court, should not do violence to the language of the contract and say that you cannot reinterpret, my lords, or rewrite the contract. In essence, that's colorful language has been used, my lords, but that's the submission. Now, my lords, I'll take, my lords, your lordship, directly to the last judgment that I've included, which is CARS 24. Lord, starts at page number. No, second last judgment, my lord, not the Zambia. Page 35. This is a Delhi High Court judgment. My lords, I just want to read paragraph 1 and then go, my lords, to the relevant part. In fact, my lords, this was a case where both the parties argued something different, but and agreed amongst each other that the Delhi High Court should exercise jurisdiction, but the learned judge said, no, I cannot agree with you. He said, my lords, I am faced here with a peculiar and quite frankly somewhat unenviable situation in which though learned counsel for both parties submit that this court has jurisdiction to entertain the present petition, I am unable to convince myself to agree. My lords, the facts, I'll take 1 minute, my lords, to explain what the facts are. My lords, courts of Delhi had jurisdiction, but they included, for section 11, there was an express clause that section 11 you have to go to Punjab and Haryana. Both the parties came to Delhi High Court for section 11 also, and they argued because the seat is Delhi, this court should exercise jurisdiction. The learned judge said, no, if the parties have chosen expressly to go to a particular court, you should go to that court. Because what the learned judge, the reasoning the learned judge applies, the learned judge applied Mankas to, my lords, the Supreme Court judgment that I read out, and then came to this conclusion. I just want to read a few paragraphs, my lords, but the facts are marginally different, my lords, from what we have. One, it was domestic arbitration, and there were 2 courts specifically chosen. We, my lords, are dealing with international arbitration. My lords, the principles apply, my lords, the same thing. My lords, first, my lords, I'll read a few paragraphs, my lords. First, my lords, para 20 on page number 38. No, it's all right. Para 20, my lords. Secondly, there is no decision either of the Supreme Court or of this court to which my attention has been invited. On para 20, my lords, on page number 38.
Yes.
Secondly, there is no decision either of the Supreme Court or of this court to which my attention has been invited or on which I have been able to lay my hands, in which the arbitration agreement specifically confers the jurisdiction to appoint the arbitrator, i.e. Section 11 jurisdiction on courts in a particular territorial location. This factor, in my view, makes a world of difference to the present case and its outcome. Learned counsel for the parties are correct in their submission that there is a long line of decisions of the Supreme Court which have examined the aspect of territorial jurisdiction for the proceedings under Section 9, 11, and 34 of the 1996 Act. These decisions have dealt with the scope of the seat of the arbitration clause as well as of the exclusive jurisdiction clause and the effect of Section 21E of the 1996 Act juxtaposed therewith. In fact, the three factors, the interplay of which would fall for consideration in all such cases are seat of arbitration clause, if any, exclusive jurisdiction clause, if any, and Section 21E of the 1996 Act. This is for domestic arbitration. But the key, is this: the number 1 and 2, seat of arbitration clause and exclusive jurisdiction clause. In our case, neither exist. We have chosen, only venue, and we have chosen one court for the purposes of enforcement of award. We have not chosen seat, nor have we chosen, nor have we conferred exclusive jurisdiction on any court for interim reliefs. We have conferred exclusive jurisdiction for the purposes of enforcement alone. Now, then, the learned judge goes, para 40 on page number 42. A reading of the aforesaid decisions no doubt reveals that preeminence has been accorded by the Supreme Court to the contractually determined seat of arbitration. This is the same line of decisions that my learned friend has submitted, and they're in their compilation also. Balco, Indus, all these cases, are considered. BGS, all of them. And then, while deciding the issue of the court, which would be possessed of territorial jurisdiction to deal with petitions relating to arbitral proceedings, whether preferred under Section 9, 11, or 34. As already noticed here in above, however, none of these decisions involved a case in which the contract contained an exclusive jurisdiction clause and a separate seat of arbitration clause. And the two clauses conferred jurisdiction on courts located at two different territorial locations. On the last date of your hearing, your Lordship posed a very important question, which, in my respectful submission, goes to the heart of the matter. Merely choosing venue in an international arbitration, does it exclude courts of competent jurisdiction to deal with Section 9? That was the question your Lordship posed. That question is not being answered except in Mankastu and these 2-3 decisions of the Delhi High Court and the Calcutta High Court. The Delhi High Court and the Calcutta High Court, dealt with domestic arbitration, but they borrow the principle of the Supreme Court in the international arbitration case. Now, the last.
We'll continue.
Yes,
How much time will take?
I may take another 15 to 20 minutes.
No, let him finish.
Yes.
I'll accommodate.
Thank you.
You ask your colleague to take.
Yes, I'm grateful. Yes.
If I may mention, my lords. My lord, serial number 10, the respondents have taken time. It's a covered by decision of the KIDB nice matter, my lords. It's a covered by decision. This must.
Nice, I'm not.
Please, office objection is there, my lords. We have given the council submission.
Nice matters, I'm not touching. It has to go to a different.
Some date may be given.
Blood one submission.
At 1:30.
Harish Tuna. Continuation. ನೋಡಿದರಸಿ ನೋಡಿದರಸಿ
Serial number 29 in the second list.
please. 29 in
Serial first list, please. Yes, Harish.
yes.
Immediately during next week, please. Immediately during next week.
38060. ಯಾವ್ದು ನೋಡಿ?
ಹರೀಶ್ ವಿ ಎಸ್
VS.
Huh? At request. 2011 matter.
Yes. He is not in town this way, please.
Date code. Relist. Yes.
February. Continuation.
Please, serial number 11, which is the next one, the revenue is being led by the ASG and I'm being led by Senior Counsel Shivdas Lordship. Just requesting if the matters could be taken up on the 3rd or 4th Lordship. 4th.
Relist on 4th.
Oblige, Lordship. I'm grateful.
Blood serial number 9 in the orders list number 1. But where I apply for one of the petitioners, blood, I would like to file my memo for retirement. The letter sent through speed post blood has not been returned yet. Your lords may kindly have it.
Which matter?
Blood serial number 9, blood WP 15469 of 2019.
This list number?
List number 1, Lord. Serial number 9, it's in orders.
No, madam, I think there's some mistake. Please check. Look at the date. Some now advanced list, cause lists also coming out. Please check. We have three lists.
Please, Lord. I shall check. Thank you.
Serial number 9. ನೋಡಿದರಸಿ
Also, I was reading the Delhi High Court judgment. Page number. Your Lordship, come to page 46 of my compilation.
Yes.
Was para 53. Was the learned judge Malot's quotes the Supreme Court judgment in Mankastu in the previous paragraphs and then reads Malot's. As such, the Supreme Court held that once the seat of arbitration has been fixed as Hong Kong, if exclusive jurisdiction for obtaining interim relief was required to be vested in courts at New Delhi, the agreement had necessarily to specifically so state. Malot's, kindly note this. Here, my lords, in our agreement, neither are there. There is no exclusive jurisdiction either for the seat, nor is there an exclusive jurisdiction for interim relief. It's deliberately so, as I submitted earlier, my lords. So that is a point, my lords, that I wanted to draw your attention to, and the learned judge rightly notes that. It was for this reason, opined the Supreme Court, that clause 7.3 had been particularly inserted in the agreement, which apart from the exclusive jurisdiction clause, i.e. clause 7.1, specifically provide for recourse to courts at New Delhi for obtaining interim relief. That clause, according to the Supreme Court, however, could be of no assistance in determining the controversy before it, as the Supreme Court was concerned not with an application under Section 9, but with an application for appointment of an arbitrator under Section 11. Exclusive jurisdiction to seek recourse to courts at New Delhi having been contractually restricted to applications for obtaining interim relief, the Supreme Court held that the locus of the court possessing Section 11 jurisdiction would have to be determined on the basis of the contractually fixed seat of arbitration, i.e. Hong Kong. I'll read one more paragraph, and then explain why this is very important. Para 59, I'll skip, I won't read everything. I've extracted whatever is relevant in the note, in the synopsis note. Para 59, if your lordships come to. On page 49, 48, no, 59. Where therefore, your lordship has that now. Where therefore the seat of arbitration is at place X and exclusive jurisdiction over the subject matter of the suit is conferred on courts at place Y, a petition under Section 11 would unquestionably lie before the courts at place X. The present case, however, is different, as the exclusive jurisdiction conferred by the arbitration agreement is not in respect of the subject matter of the suit, but specifically for appointment of arbitrator. It would be doing violence to the said clause. Therefore, if this court were to treat the exclusive jurisdiction clause as limited to the subject matter of the suit and exercise Section 11 jurisdiction contrary to the mandate thereof. Now, what the and paragraph 60, my learned friend is rightly pointing out, it is right that a court cannot rewrite a contract between the parties. Where the contract between the parties, as in the present case, confers exclusive jurisdiction for appointment of an arbitrator on courts at Haryana, any petition under Section 11 would have to be preferred before the High Court of Punjab and Haryana and not before this court. There is no decision to which my attention has been invited, which persuades me to take a different view. Lords, what is in our clause? In our clause, exclusive jurisdiction for enforcement has been conferred on Mumbai. That cannot be extended to Section 9. There is no exclusive seat also in our clause, and this is important, because unlike in domestic arbitration, this is international arbitration under an institution. So the intervention of courts, even after the arbitral process starts, is extremely limited because the institution does all the supervision, So it is not a domestic arbitration, ad hoc domestic arbitration, where the courts have to intervene for matters of procedure, etc. Matters of procedure are in accordance with the LCIA rules as per here. So where there is an institution selected and a specific exclusive court selected for enforcement and interim relief left open to all courts of competent jurisdiction, what the respondents are now arguing is that you exercise exclusive, they want to confer exclusive jurisdiction to Mumbai for everything which is not permitted, which is what the case law suggests, Now, I will read, only three judgments, I'll only read one paragraph each. I won't read extended paragraphs, Next judgment, in is a Calcutta High Court judgment. I'll only read if your lordships come to come to page 23. This judgment starts at page number 12. Page number 12, I'll just read the conclusion. It starts at page 12. Your lordship come to page 23. I'll just read the conclusion. Para 21. Contractual interpretation necessitates taking into consideration all clauses and relevant factors to propound the proper intention between the parties. The rule of harmonious construction must be applied so that a panoramic meaning can be given to any agreement. The law with respect to arbitration clauses, as laid down in BGS, SGS Soma and Mankastu Impex, is not alien to such interpretive principles. In light of the Apex Court's decisions in these two judgments, other clauses have to be scrutinized when a location has been mentioned as venue or place to fathom if such a location can be dignified with the status of seat. In my opinion, a clause opting a place as a venue or place read with another clause which mentions courts of another location to have jurisdiction over disputes that may arise inhibits the promotion of such venue to seat. The intention that emerges from an aggregate understanding of such clauses is that the venue or place was to be a convenient location for holding of arbitration seatings. The courts of the place selected as having exclusive jurisdiction over disputes should be considered as seat and having jurisdiction to entertain applications under the Act. My lords, again, my lords, coming back to our clause, my lords, ultimately we have to deal with our clause. Exclusivity is only granted for enforcement in our clause to Mumbai. That, my lords, cannot be taken away. I cannot come and seek enforcement here because exclusivity is granted there. But that exclusivity cannot be extended to everything else, is my respectful submission, when there is a specific reservation for any court of competent deal with interim relief.
Such clause is not contrary to any provision.
No, my lords, not contrary to any provision. In fact, my lords, I'll read out the LCIA rules also. The LCIA rules specifically provide for that. Rule 25.3, I'll point out, and an English High Court dealing with a similar situation, interpreting clause 25.3, said that LCIA rules envisage that any courts of competent jurisdiction have the power to grant interim relief, even though in that case, the arbitration was supposed to be held in London under the LCIA rules. But parties approached the Zambian courts for interim relief. And the court said, no, LCIA recognizes this. And also, then the question of which court has a competence to grant the kind of interim relief being sought for. That is a question that the court will have to deal with.
No, in so far, I'm just asking.
Yes, ma'am. Yes, ma'am.
So, as international arbitration is concerned, you have one scenario wherein it's outside. You have a clause, section 9.
Yes, my lord.
Now, if it were to be in India.
Yes, my lord.
And let's assume that under normal circumstance, your 9 will be where the main arbitration is going to be conducted normally.
No.
In the absence of.
In the absence of reservation. In fact, my lords, before the 2015 amendment, that was the case. That unless, my lords, if seat was chosen, that there would have ended the matter. 2015, the proviso to 2.2, it flips the burden on the parties. It says, Section 9 court to grant interim relief power exists unless parties indicate otherwise. Now, of course, which court has to exercise Section 9 power is what we are discussing with. But earlier, if it was before the proviso, if it was international arbitration, after Balco, the default was you cannot come to Indian courts for Section 9 at all. Now, the regime is, after Monkus 2, the 3-judge bench, that you have to examine the provisions of the contract to see whether you have reserved the right to grant interim relief. My lords, nevertheless, even, my lords, just, my lords, hypothetically speaking, for example, my lords, if my learned friends had to seek the interim relief against me, my lords, to say that don't dispose of any assets, they would have to come to this court, especially if it was immovable property, wherever the arbitration was being held. This question, my lords, and, my lords, the point my learned friend was reminding my lords is Section 9, my lords, is not supervisory jurisdiction. Section 11 is supervisory jurisdiction. Any appeals, my lords, from after the tribunal is constituted, all goes, my lords, to the supervisory court. In this case, my lords, there may have been a case, my lords, if I had come under any other provision after the arbitral tribunal had been constituted, the respondents would have been, my lords, validly raised the argument, and correctly so in my view, that this court should not exercise jurisdiction. That jurisdiction would have been either with the LCIA, the institution, or the venue, because we have not chosen the seat. Therefore, my lords, where this Section 9 stands in a different, on a different footing and in a different bucket, even as per the agreement and as per the LCIA rules, my lords, which I will show in a short while. Yes. My lords, I'll read, my lords, para 22 also. In the facts of this case, Exhibit 2 of the MRA mentions that the arbitration shall be conducted in accordance with the Arbitration and Conciliation Act, and the venue of such arbitration shall be in Kolkata. However, it cannot be analyzed in seclusion of the other clauses. Due regard must be paid to other clauses, if any, which may act as a contrary indicia to suggest that parties intended the venue to not to be seat of the arbitral proceedings. It is clear that clause 25 contained in the MRA, which confers exclusive jurisdiction on the courts in Mumbai, rising out of the agreement, is a contrary indicia and shall proscribe the upgradation of Kolkata from being a mere venue to that of seat. The courts at Mumbai, in my opinion, possess the jurisdiction to entertain the instant petition and other applications under the Act. Correspondingly, this court does not have the jurisdiction to entertain this instant petition. So on the facts, my lords, he came to a different conclusion against what was being sought in the petition. Now, my lords, only two more judgments I want to read, my lords. One is another Calcutta High Court judgment, my lords, on party autonomy. I won't, my lords, to take too much. I won't read too many paragraphs. Just one paragraph, my lords, para 29 on page number. No. Bolopedia. 32, my lords, page 32. Just paragraphs 29 and 30, if you watch this mark. The Act of 1996 has recognized party autonomy. It has recognized the power of parties to choose the law that will govern the contract and the arbitration. It has recognized the power of the party to select the applicable procedure for arbitration between themselves, to select arbitrators to adjudicate the disputes and the seat of arbitration. To select applicable procedure, to select arbitrators and the seat of arbitration. As I read out, my lords, even with respect to review of the award, the parties have made a choice here. They have given only a limited review to any court. That's what they have agreed between themselves. The seat of arbitration, so far as international commercial arbitrations are concerned, has importance. The seat of arbitration, as has been held in Mankastu so-and-so, is a vital aspect of any arbitration proceedings. It determines the applicable law when deciding the arbitration proceedings and arbitration procedure, as well as judicial review over the arbitration award. The situs is not just about where an institution is based or where the hearings will be held, but it is all about which court could have supervisory power over the arbitration proceedings. Because I am not coming under supervisory proceedings here, my lords, at all. There is a distinction between the seat of arbitration and the venue of arbitration. This distinction has been noted and explained in Mankastu. Mankastu has, however, dealt with the question of seat of arbitration and a conflict between the seat of arbitration and the court selected under the forum selection clause in the context of an international commercial arbitration. Lords, in this case, what the parties have done is they have selected Mumbai for certain things alone, which is for enforcement. For everything else, they said for everything else means only the remaining only aspect is the interim award, my lords. Emergency interim relief. They have said you go to courts of competent jurisdiction, deliberately so, my lords. Now, my lords, for a moment, just for a moment, my lords, if I had gone to Mumbai, the first thing I would have to show to the Mumbai court is how do they get the power to give me relief under Section 9? Because all the parties have granted to the courts in Mumbai is enforcement of the award. And I have the Mumbai court is not a court of competent jurisdiction as far as these two parties are concerned. And the contract is concerned. Mumbai court, my lords, it has no connection with the contract. The connection to the Mumbai court is only because we have granted the power to enforce the award. And we have chosen that, venue shall be Mumbai. Therefore, now when I come to the court of competent jurisdiction, it cannot be that, the 34, if I was to enforce an award, I should have gone to Mumbai. If I go to Mumbai now, I don't have a clause to rely on to say that this court has, the Mumbai court has jurisdiction. The only court in India that has jurisdiction is this honorable court. If I were to seek against any assets, my lords, if I was to say, let there be a lien over certain assets, then I would have to chase the assets depending on where they are located. The defendant, my lords, is a multinational corporation. They have some assets in India, there are some assets in Singapore, some assets in worldwide. That's a different issue altogether, my lords. Now, my lords, the only one more judgment, my lords. Sorry, my lords. Kindly note, my lords, in that same page, para 33. I won't read it, my lords, because it's about party autonomy. The judge expounds on party autonomy, my lords, as to how the intention of the parties is important when any clause, my lords, is interpreted. Now, my lords, if your lordships come to the last judgment, it's an English High Court judgment. My lords, starts at page number 54. And I want to read, my lords, para 65 on page number 65, my lords. Page 65, para 65. It's there are two columns, my lords, in the left side of the page. Para 65, my lords. However, it is not necessary to decide that point because it is common ground page 65, my lords, of the compilation.
Yes.
Para 65, my lords, there are two columns on the left hand side of the first column, my lords. 65. Because it is common ground that the matter is governed by agreement between the parties. The agreement provided for an LCI arbitration, and KCM, my lords, one of the parties, places strong reliance on the LCI arbitration rules in this regard. Article 25 of the rules deals with interim and conservatory measures. KCM places particular reliance on Article 25.3, and the other party, UNM is the other party, my lords, refers to earlier parts of it. And I shall set out the whole article. My lords, and then in the right side of the column, my lords, 25.3. This, my lords, the judge is extracted, my lords, the LCIA rules. Our rules also the same, my lords. I shall provide a copy, my lords, it's the same article also, my lords. 25.3. The power of the arbitral tribunal under Article 25.1 shall not prejudice, howsoever, any party's right to apply to any state court or other judicial authority for interim or conservatory measures before the formation of the arbitral tribunal and in exceptional cases thereafter. My lords, in our case, my lords, the tribunal has not been formed. We have both appointed our respective nominee arbitrators. There is some difference of opinion, my lords, between the two arbitrators about the procedure to appoint the chairperson. That, my lords, is still going on. My lords, and then, however, by agreeing to arbitration under these rules, the party shall be taken to have agreed not to apply to any state court or other judicial authority for any other order for security for its legal or other costs available. That's the only restriction, my lords. Now, the difference of opinion between the parties can be briefly stated. KCM submits an application to the local court for interim measures is explicitly anticipated in Rule 25.3 with its reference to any parties right to apply to any state court. UNM submits that the point can be dismissed immediately. Unlike some other institutional rules such as those of ICC, it submits LCIA rules confer no right to seek interim relief from any court. They merely make clear that conferral on the tribunal rights shall not prejudice any right to seek interim relief from any court. And then, my lords, the judge goes on in para 68 on the next page. It is not immediately apparent to me why UNM suggests that LCIA rules should have a more limited effect than the ICC rules, or for that matter, the Anticipatory model law. But of course, it depends on their true construction. In my view, construed against the above background, Article 25.3 of the LCIA rules does not have the limited effect that UNM argues for. By expressly stipulating that the power of the arbitral tribunal to order interim and conservatory measures is not to prejudice a party's right to apply to a state court before the formation of the arbitral tribunal, in my view, Article 25.3 implicitly recognizes the party's right to do so. And then, my lords, the conclusion was, my lords, the 71 and 72, the learned judge says, you please go back to Zambia, and the English court, my lords, is not the right court to grant such a relief because the arbitral tribunal was not yet constituted. And the case also discusses very briefly the point that I made earlier also, that interim reliefs are not in the rate before the tribunal is constituted, my lords, are not in the character of supervisory jurisdiction. My lords, what my learned friends have argued is the courts of the seat of the arbitration have supervisory jurisdiction. On that, I have no quarrel. That is not what I am arguing here at all, my lords. We are in a supportive jurisdiction, which comes to before the arbitral tribunal, my lords, is constituted. Now, my lords,
if it were to be domestic.
Yes, my lords.
And there was no clause differentiating between interim measures.
Yes, my lord.
Then it would be the court which has jurisdiction in the main seat.
Yes, my lords. Courts which have jurisdiction in the main seat unless parties have chosen specifically to say interim relief in this court, which is what, my lords, the Delhi High Court and the Calcutta High Court have now taken the view after the following the decision in Mankastu, that, my lords, your lordship, that this is the, my lords, if, my lords, we say Bangalore is a seat and keep quiet, the courts in Bangalore should exercise everything, supervisory, supportive, everything, subject, my lords, to immovable property and other things, limitations on court's power, which territory and all of that. But if the parties say seat in Bangalore, but for interim reliefs, you go to courts of Mumbai. The courts, my lords, the Delhi High Court and the Calcutta High Court say that you should recognize that express choice. Where you have chosen a forum, you cannot say seat overrides the forum. That is the point, my lords. And here, either way, in our case, whichever way we look at it, it works, my lords, the clause works in my favor, because what is chosen is for Mumbai only for enforcement. That cannot be extended to everything else.
But here, it only says competent.
That's the point, my lords. Unless even for competent, for interim reliefs also Mumbai was chosen, then, my lords, I could not have come here. Because for interim reliefs, the clauses, the parties have chosen only competent jurisdiction. That's why, my lords, we are here. And my submission is we don't have anywhere else to go if it's in India.
Yes.
Now, my lords, the LCA. My lords, I'll come back, my lords, to the agreement. My lords, in terms of case law, my lords, I won't read any other case law, my lords. In my note, I have extracted the relevant paragraphs, my lords. My submission, my lords, finally, is that where, my lords, it's the rules of my lords, so my lords, two things are important. One, what are the parties chosen? If the parties, my lords, have chosen a particular process and given different, my lords, differentiated between different stages of the arbitration, that should be respected by this honorable court. The parties have said, as far as enforcement, we will go to Mumbai. Place of the arbitration is Mumbai. For everything else, they say you go to court of competent jurisdiction. That, my lords, has to be respected, is my respectful submission, because it's a clear and intentional departure from saying courts at the venue should have the right to grant interim relief also. Now, my lords, on the facts, just two more points, my lords. If your lordship comes to my application, because my learned friend argued on the last date that the agreement has been entered into in Singapore. So how will this court have jurisdiction? My lords, the parties, my lords, my office is based here. The consideration, my lords, that I received is based here. I received in this, my lords, town. My lords, then the amount that I am now claiming was to be paid to me here in the city of Bangalore. My lords, and the execution of the contract also. My lords, your lordships, I want to point out, my lords, that is also an indicative. If your lordships come to page number 25 of my application.
Insofar as the IA,
yes,
you have not filed formal objections, sir.
Well, no, I think they filed a preliminary objection. IA, interim applications.
No, there's an application filed for rejection.
Rejection.
For that you have filed objection.
No, my lords, my view is, my lords.
Correct. Agreed. But since anyhow I'm going to accommodate another date,
I will file a one page.
Let it be on record because we are hearing on that.
My lords, I'll mention, my lords, my submission, my lords, is that because this is an interim application in the first place. Now, an interim application under the interim application is as good as the preliminary objection to dismiss. I'll file, my lords. I'll file a 2 pages.
Page?
Okay. My lords, if lordships come to page 25 of my petition.
ಗೊತ್ತು. Yes.
Clause 25 is where the agreement starts. Now, if your lordship comes to page 26. See, my lords, where we have paid the stamp duty. My lords, and kindly underline the date, my lords, on which we purchased the stamp paper. That's important, my lords. 7th October 2014. On the second line, my lords, after certificate number, certificate issue date, anta idiyalla, underline, my lords, 7th October. Then, my lords, what has happened, and then at the bottom of the page, my lords, we are saying agreement for sale of the acquired assets by and between Jagdale and Johnson & Johnson, dated as of October 9, 2014. Now, my lords, my learned friend is relying on the on page 32, where it says this agreement for sale and purchase is entered into at Singapore as of October 9, 2014, to say that there's no connection to Bangalore. What? Now, my lords, parties, when they're signing agreements, my lords, they sign from different places. I was here, my lords. We have purchased stamp paper here. We have on 2 days before, my lords. It's not the case where an agreement was signed somewhere else and later brought into the city and stamp paper paid. This is purchased earlier for execution of this agreement. Then, my lords, the second, the another, my lords, the factual matrix, my lords, is that my registered office is here and the consideration was received here, and the entire dispute, my lords, is related, which, my lords, in your lords, just to give an indication of why we are here, my lords, I am claiming that I complied with some non-compete terms for which they are supposed to pay more consideration. The dispute is about whether consideration is payable or not. My learned friends are saying it's not payable. My simple point is the money has to be paid here. So the only court, my lords, and the books and records of the assets that I sold to them were all here with me here, which then I transferred to them. My learned friend rightly pointed out that it is not an immovable asset. It is basically books, documents, intellectual property, all of that. But all the books and records were here, my lords. The movable assets were all here. And that is the point, my lords. And section 19, my lords, of the CPC, if we are determining the competent jurisdiction, I am here, I have received the money here, and my submission is the contract in terms of payment is paid here, and the damages are seeking is to be paid here, my lords, not anywhere else. So that, my lords, in some, my lords, our submission is that the parties deliberately chose that as far as interim relief is concerned, competent court exercising jurisdiction has the right to grant interim relief. The LCIA rules also permit us to do so. The only exclusion, only selected forum in terms of exclusion is in respect of enforcement of the award. And courts, my lords, have to respect party autonomy. I'm grateful, my lords.
Release the matter. Learned senior counsel Sri Harish has advanced arguments on behalf of the petitioner. The reply for further arguments of the other side released on 4th.
And I'll file the objections by then, my lords, for that application.
10, 11, 12 Arjun, 13. Okay. Ravindra Reddy.
Relist.
13. Next to do, preliminary matters, still number 30. Kumar Shetty. Arvind Chauhan.
ವಿಡ್ರಾ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು. ಇದು ವಿಡ್ರಾ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು. ಹೌದು ಸರ್. ಪಾಸ್ವರ್ಡ್ ಬರಲಿ ನೋಡಿ. ಪಾಸ್ವರ್ಡ್
31 Arjun. 32 Kalyan R. 32 32 Kalyan.
just relist date.
33 serial number 33 Malaya MR.
I appear for petitioner, my lord. My lord, I have filed for dispensation with the certified copy of consent award, my lord. The consent award, they are not going to issue consent award certified copy, my lord. If your lordship permit, I proceed with the.
Fresh matter. This is a fresh matter.
Yes, my lord.
So then you take out notice.
Yes.
BDR. Anjana.
PDS.
Now, Counsel Shri B. Vachan is directed to accept notice for the respondent.
Great.
34
The IA 1 of 25 has allowed petitioner dispense with production of certified copy by XG for the present. Yes.
Serial number 31.
34
31 is
30.
31.
I think somebody has taken time in the connected matters.
I am for the I am not informed behind for the petitioner.
5th of February.
5th of February.
5th of February.
My lords, 34, I appear for petitioners, my lord.
Yes.
My lords, in a similar set of matters, the coordinate bench has already passed the orders, my lords. We are awaiting for the orders. It may be urgent by 2 weeks, my lords.
List after 2 weeks at request.
Interim order to be extended, my lords.
Modern operation extended till the next date.
Much obliged, my lords.
35 Pradyumna.
My lords, service tax demand based on third party income tax data, my lords, covered by Chinmaya. I'm calling.
Based on the 26 years, it's been passed.
ಅದು ನಮ್ದು ವಿತ್ತನ ಮೊನ್ನೆ ಮಾಡಿದ್ವಲ್ಲ. ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್.
Demand for the year 2016-17, my lords.
I'll have it tomorrow. Some identical, I passed some order, I think last week. I'll just.
Please, my lords.
Huh?
Which one of the matter that I have appeared, lordships have passed an order.
Lords have passed an orders in our matter. If I could tell the number. 27177 of 25.
Okay. Last week.
Please, my lords, last week. 20th Jan.
So you get it, we'll have it tomorrow.
It's not yet released, my lords.
ಡ್ರಾಫ್ಟ್ ಆಗಿದೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ. Tomorrow?
Lords could, my lords have a day after tomorrow, but some inconvenience tomorrow. Day after, if my lords.
Tuesday in the fresh matters list and video.
Please, my lords, please. Obliged.
Tuesday in the fresh matters list. Lord Counsel Akash Shetty is directed to accept notice for the respondents.
36.
This is the matter against the BDA, my lord, where they have refused to execute a sale deed in respect of lands that have already been allotted.
Yes. That you verify now is a old matter. This. They only want an absolute sale deed.
Yes.
So you complete, you say when we can, it's already 9 years.
Longer, my lord.
When you want, shortest date you say, and you conclude it.
In fact, we've carried out verifications on the BDA website as well, pursuant to an order of this
Monday,
court.
no further time.
No, in fact, pursuant to orders of this court, the BDA had to publish a list of litigated lands as well with respect to this layout. Now, this site falls in survey number 59. As
Yeah.
per the BDA's own record, there's no litigation pertaining to this site.
Monday, if you don't come, I will proceed.
My instruction is under process and process of the selling. But they were.
Not 9 years, not 9 years. If they want his client to come to the table of this officer, we will not allow. We will fix a time limit, but you first find out. Not after 9 years. I'll have it on Monday. Monday. But no further adjournment. It made clear that the learned counsel for the respondent BDA seeks for a final adjournment. It's made clear that there would be no further adjournment on Monday. Reach the matter in the same stage on Monday. Let them finish whatever they have to. Otherwise,
Very well.
it will spiral out into other litigation.
No, our last hope is this court. So if they are before your lordship stating that they will verify and then take necessary steps, that should serve the purpose. My only concern is that this is the third round of litigation.
No,
I had filed a writ petition in 23, no response. 24 directions were passed, nothing has happened pursuant to a high court direction. That is my only concern.
No, we'll see. And then you don't have to wait for any order of the court. I will keep this matter pending till you execute a sale.
I'm so grateful. I'm so grateful.
Monday, yes. Find out and let it be done. Till then, we'll keep it pending and we'll have it regularly.
I'm obliged.
Yes.
I'm obliged.
38, Lakshmi Menon, Arvind, come on. You're into the petition.
So GST matter, my lords, where the show
Wherein
cause
for
notice.
respondents, let's seek 1 week of time to file objections.
The issue is relating to financial year 17-18, where the demand is raised in respect of difference between 2A versus 3B. That is what supplier has uploaded in his 2A versus what I have uploaded in my 3B. Lord, interestingly, at that point in time, there was a section 42 in which is subsequently being omitted in 2022, my lords. The procedure to be followed then in 17-18, my lords, was that once the department finds there's a difference, the department has to issue notices both to the buyer and to the seller, my lords, to find out what is the difference. And only in case where there is no response to the by the seller, my lords, then only then can the department initiate proceedings against me, my lords, because I have paid tax to my seller, my lords, and he has not filed his return or paid the tax to the government, my lords.
Let us see. Next Tuesday. Release. Next Tuesday, same stage.
My lords, I wish to file this. I've gone. The order is passed. I've gone on appeal. This I filed a condemnation as well before the appellate authority, first appellate. I wish to file the condemnation of delay. It is not in the petition by way of memo. Man.
Memo filed is taken on record.
39,
Like,
I appear for the petitioner in this case, my lord.
Yes.
My lord, the order at Annexure A has been passed without providing me an opportunity of hearing. There are earlier writ petitions that were filed. There are center and state, both authorities had issued show cause notice.
Just 1 minute. Just G1.
G1 39.
I'll pass over. Let him come. Let him come.
Please, my lord.
Pass over.
40. Mihir Ram, Kiran Kumar.
For petitioner, my lords.
They have to take their stand.
Please.
The interim direction earlier passed is extended till the next date. Relist the matter on.
41. Has 2 minutes.
Yes.
Hearing for the petitioner, my lords. So this is a service tax matter, my lords. Chinmaya, where the show cause notice and order has been passed, considering my,
We will taken up on Tuesday.
my lords.
There's
the issue-
another matter I've posted on Tuesday. I'll have it with the
My lords, I'm an individual. My bank account since 31st December has been attached. I'm unable to pay my EMIs also, my lords. I was having a business providing export of services, my lords.
Tomorrow.
Please, my lords. Pledge.
ಅದೊಂದು ತೆಗೆದಿಟ್ಕೊಂಡಿರೋದು ಅದೊಂದು ಚಿನ್ಮಯ ಕೇಸ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ದೀವಿ ಯಾರು ಮಾಡ್ಕೊಂಡು ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ 26 years ಸರ್ವಿಸ್ ಟ್ಯಾಕ್ಸ್ ಆಕಾಶ್ ಶೆಟ್ಟಿ ನಂಬರ್ ಕೇಳಿ ಆಕಾಶ್ ಶೆಟ್ಟಿ ನಂಬರ್ ಕೇಳಿ ಅದ್ರದ್ದು ಪ್ರಿಂಟ್ ತೆಗೆದ್ಬಿಟ್ಟು ಇರ್ತಾರೆ
41. 42.
My lord, I am for the petitioner, my lord.
Yes.
Kindly a week time may be given, my lord.
Let's we have filed a memo, and that's 42 for 2 and 3.
For amendment cost list, my lord. A week's time may be granted, my lord.
Relist date code ಅಷ್ಟೇ date code
Can I pass on the order document? Date of 3/9/2024. As the counsel for respondent 2 and 3 submit the petition number 15 has agreed to take a developed land as a compensation in review of monetary compensation for acquiring this land and has agreed to withdraw the writ petition and raise the writ petition to be dismissed as on petition number 15.
15.
Yes, my lords. The same way, my lords, we have filed a memo, my lords, for the petition number 1, my lords, in 42.2, my lords.
Petitioner number 15. 15 or the whole petition?
This is acquisition.
Correct. ಇದೆ ತಾನೆ?
This is paying a compensatory past order. May I take memo filed on the 3rd November, my lords. In this, my lords, para number 3, my lords, the learned counsel for the respondent number 2 and 3 submits that petitioner number 15 has agreed to take developed land as a compensation in lieu of monetary compensation for acquiring the land and has agreed to withdraw the writ petition and the writ petition may be dismissed as petition number 15 is concerned, my lords.
Correct. So what has happened to petition?
We have also filed another petitioner number 1 and petitioner number 2, 5 and 6, my lords. It may be dismissed on these petitioners. A memo has been filed, my lords, on 3rd November of 2025 in WP number 3174.
What do you say, madam?
We have served a copy also, my lords.
Okay.
Just
42.
a week's time may be granted, my lord. We will be doing that sufficient.
Yes, sir.
You have to complete your instruction, madam. You can't simply ask time. Now you have said you
The parties are agreed, my lords, in this.
Correct. Now they must at least have some instruction. I'll have it tomorrow. You make submission on this one. Release tomorrow.
Okay.
Yes.
Okay.
Otherwise, I'll dismiss it in so far as such of the petitioner. Yes, next.
We'll be making it ready, my lord.
Tomorrow. Yes.
Obliged.
Much obliged.
43.
appear for the petitioner in this case.
Yes.
My lords may kindly bear with me. The land involved, initially the dispute was that my land was not notified, but possession was taken over and I had filed a writ petition. Prior to that, I had obtained a permanent injunction against BDA not to interfere with my possession. In the first instance, my writ petition was disposed of, directing BDA to consider my representation. After that, BDA rejected my representation on the ground that they had deposited the money already in civil court, which was challenged by me. During the pendency of the writ petition, several directions were issued. One of them was to the ADLR to conduct a survey and identify where physically the land was located. Another was for the BDA to specify how, when the land was not notified in the notification, they had deposited the money. Now, on the last occasion, my lords, the report which had been filed, there is an observation by the ADLR that the land belongs to government without referring to any documents. Now, I have produced my sale deed of 1967, the mutation record of rights after that, and the RTC continuously. And based on this one observation, the court had asked me to produce grant documents from the government. Now, despite the fact that there is nothing to establish that this is government land, I did verify, and there is nothing available by way of indication that this is government land, and consequently there is no grant order available. Now, the basic facts, my lords, is that there is a notification under which BDA acquired survey number 1 of Jarkamante Kaval, Yashwantpur village, and my land is in Jarkamante Kaval, Yelanka Hobli. Initially, I had filed a writ petition, which was rejected on the ground that I have come belatedly to challenge the acquisition notification, against which I filed a writ appeal in which liberty was given to me, stating that I have to go file a civil suit because my contention is it is not included in the notification, which I did file, and I obtained a decree against the BDA by establishing as a fact that by producing the notifications that only Yashwantpur is notified and Yelanka is not notified. Therefore, the civil court granted me an injunction against the BDA. Against that, BDA filed an RFA. During the pendency of the RFA, BDA came and reported to the court that they have taken possession of the land. RFA was disposed of, saying then parties are entitled to take recourse to whatever remedy is available. Now, after that, I filed a writ petition asking for a direction to the BDA to either restore my land back to me or acquire it in accordance with law and give me compensation under the 2013 Act. That was disposed of by this honorable court, stating that the BDA should consider my representation. Now, in considering my representation, the BDA again fell back onto the contention that they have deposited X sum before the city civil court because there is a dispute and that I am to avail that remedy. I pointed out that, my lords, because my name is not there in the notification, my land is not notified, there was no way they could have deposited the compensation in my name in the civil court. That was one of the directions given by the court: produce the documents to show how it is deposited. Now, during all this, when the matter was being considered, the honorable court also directed that physically where the land is located, you identify and report to the court, so that if actually BDA has taken physical possession, then further directions will be passed. Now, in giving that report, my lords, the surveyor has filed the report where, in passing in one paragraph, at page 3, my lords, of that report, it is filed separately along with the map.
Memo dated 29/24.
The copy served on me does not have the date, my lords.
Sketch.
Sketch, my lords, this sketch. Now, my lords, as per the sketch, my land is identified as coming in the road.
103.
103. That pink portion is identified as my land. It is coming in the road.
According to contention that he says his land is this.
Yes.
Not anything else.
Yes, sir.
He identifies
his land to be falling under this portion. That's why the ADLR identified this land. Because this, it has been stated that this property cannot be identified now in view of the developments. This is how Lord, this situation is.
My
This is
lords,
what
may
they contend that according to their sale deed, according to the way that the title has flown to them, they identify this is the portion that land belongs to. That's all, Lord. It's not not an identification that a particular portion of a 1 acre and odd, 2 acre and odd is this land, is the pink portion. That's a dispute. That is the not issue. Sorry.
My lords, I may just point out the legend in the map itself against the pink serial number 3. It reads, the color denotes the possession as shown by the writ petitioner A.V. Krishnaswamy. The said piece of land is an acquired area of outer ring road and ramp of grade separate bridge. The said land has been acquired by the BDA by notification number so and so, number 2 of 7778 dated 16/11/77. Possession of the land colored in pink measures 1 acre, which does not have any related revenue sketch, also has not been restored in survey records, and no new number has been assigned to it for want of original grant records from Revenue Department. Amount of compensation to be paid to the original grantee has been deposited in civil court as told by official of BDA, who was on the spot at the time of joint inspection. The information regarding availability of grant records has to be answered by the Revenue Department.
Now, you are claiming it originally through grant, is it?
No, my lords. My statement is that I have my sale deed in the year 1967. In that sale deed, it is mentioned it is acquired by somebody else under a sale deed. And from then on, the revenue records are mutated in my name. I have produced all those documents in support of that. And now, if I go back to the Revenue Department and ask them for a copy of the document, they are saying there is nothing here. Even the records are destroyed. We don't have anything. So I am not able to trace beyond 65, 66 or 64 as to what the document is. Now, my lords, the entire controversy is this surveyor has observed in para 2
Yes.
the impugned property survey number 1 of JB Kaval village. It is a government land measuring 519 acres 37 guntas. Out of this land, 1 acre of land is claimed by Krishnaswamy by virtue of sale deed from Rangaswamappa, son of G. Govindappa, who stated to have been granted, but the grant record is not available.
You're reading at
Second paragraph, my lord. After the sketch, there is one page, para-wise remarks. Second page, third page of that report, my lords. Page 3, para 2. Brief facts of the case is the heading, my lord. At page 3 of that.
My lord,
Filed by the government.
memo, my lord, filed by the government, my lord. First, please. Page 4 in our
3 and 4.
brief facts of the cases. In that, my lord, second para.
In that second paragraph, my lords, the impugned property, my lords got that, is survey number 1 of JB Kaval village. It is a government land measuring 519 acres 37 guntas. Out of this land, 1 acre of land is claimed by A.V. Krishnaswamy by virtue of sale deed from Rangaswamappa, who is stated to have been granted, but the grant record is not available. The portion of land granted to the extent of 1 acre in huge area of government land which has not been restored in survey records. No new survey numbers has been assigned to it, and the boundary of that granted 1 acre has not been decided in survey records, and no tipney is available to the extent of 1 acre. Now, my lords, this is the basis on which the stand is taken by the state government that this is government land. No document is produced, and in fact,
No, correct now. If the sale deed is there, revenue entry is there. After 67, let us assume after 67, sale deed is there, mutation is there, continuous revenue entries are there. And you can't go beyond 67.
No, we are not going beyond it. What we have said in our endorsement is, see, you are claiming that you have a right over this property. Insofar as we are concerned, for the survey number 1, we have passed an award. We have deposited in the civil court. Please go and claim the compensation from the civil court, because I cannot adjudicate as to who is the owner of the property, whether he is X is an entitled or Y is entitled. But there are several claimants for this survey number. I can't adjudicate as to who is the proper person to receive a particular portion of a compensation from me. So I have deposited it in the civil court. I have not denied his right of entitlement. What I have said is only, please go and take it from the civil court under where it is under deposit under section 3031. It is for them to go and claim that compensation. It is not as good as what I am not denied. If I had said that you are not the owner of the property, you are not entitled.
No, now they're not denying it. They're saying you go there, whatever is stated are only prima facie findings and will not come in the way in case you want to take compensation to it.
My answer to that, my lords, is Annexure F, where I have gone to the civil court, and as a matter of fact, I have established that my land is not notified. And I have got an injunction against the BDA. Under such circumstances, when there is no notification for acquisition, there is no eligibility for them to deposit it anywhere as claimed by them. And that is exactly the mistake they have committed in rejecting my representation. They have not referred. This is binding on them. When I have established as a matter of fact, my lords, Annexure F.
Is this land acquired or?
So this is the part of the land acquired. Lords may kindly take page 131. Lord.
No, but he's saying the village is different. Yashwantpura,
It is into two different villages of the Hobli. Lord, the entire land. That is why, Lord, whether it falls within Yelahanka or Yashwantpur. Lord, this is why specifically, Lord, the area was sought to be measured. And Lord, this is why, Lord, Lord may kindly take this. The survey number 1, date, identified. And Lord, this falls clearly within the land which has been notified by the Bangalore Development Authority. This has not been challenged.
My lord, then I may have to impose. I may have to impose to read Annexure H. That is the judgment of the civil court, specifically on the point.
That has been nullified in the appeal.
No, my lords, that is not the case. That is not the case. Please, RFA, it's been. I have produced the order also.
Lord, once, Lord, may kindly see in the suit, it has been claimed that my village falls in an X village, and this X village is not notified. Lord, this is the finding. The RFA, Lord, there was a finding against the Bangalore Development Authority, and Lord, and appeal was filed. In the appeal, which may kindly see, they make a submission. It's a suit for bare injunction, not a suit anything else. Suit, the RFA was disposed of on the submissions made by them, saying that the possession of the property has been taken over, and the suit for bare injunction will not survive for consideration. 2007 is the order of the this honorable court in an RFA. Thereafter, after 2017 is the order. After 4 years, they come before this court in the present writ petition. Lord, may kindly permit me to read my endorsement. Lord, may kindly page 131.
Readings are complete.
Lord, the affidavits of the I have filed an affidavit of the land acquisition also, pursuant to which, Lord, there was an order for measuring the property. Lord, when we said it cannot be identified, the area what they are claiming to be in their possession and ownership cannot be identified. But they claim ownership over a property. But the surveyor clearly says that this comes in the ramp, which is ramp formed by the BDA.
No, correct. Now, when you acquire it, sketches are prepared, isn't it, in the LAO's proceedings?
No, it's a vast,
land acquisition.
Yes, it's a vast extent of the land. I will point out, Lord, as to 393 acres of land in a particular survey number is acquired. He claims 1 acre out of it, but it's a government land. Lord, there has to be a grant, OD, duress, in favor of anybody or anybody claiming a right over the property. If a grant is there for an extent of 1 acre or maybe of 4 acres of a land,
but then sale deed and revenue entries, how you are getting? Sale deed and revenue entries?
No, we are not denying them a compensation. I cannot deny for in fact, Lord, I cannot deny the compensation. Their entitlement, I cannot deny, Lord, for at any point of time. What now I am trying to say is, it is not as if I have acquired the land without acquisition procedure.
No, now just to understand. Now, if it comes within area utilized by BDA, even as per the sketch, what you have shown appears to be a part of the road which they have utilized, then your right for compensation will consider.
In fact, my lords, my specific writ petition is let them give me compensation because I recognize the fact that there's a road there. It will cause public inconvenience. I am not insisting that that very land be given to me. All I am saying is give me just full compensation in accordance with law. That is all.
Lord, may kindly see the prayer form, Lord. This is
No.
why I'm objecting.
No, no, he may give up the other prayers.
No, no, prayer 4, how the compensation is sought for is my concern.
Prayer 4 is in accordance with the decision of this honorable court, my lords.
I'm not onto that. Lordship, may kindly permit me to read. In the alternative, pay compensation for illegally taking possession.
No,
That's
no.
where I am into. If he is entitled for a compensation, not I cannot. There are two issues.
No, now they say they have deposited the amount before the reference.
It is not there, my lords. I have verified it is not there. That is why there is a direction given to them also to produce the records. That is also not there.
Now we'll do one thing. First, we'll ascertain as to whether you have deposited in so far as this.
Yes.
So in the reference, they send some.
Yes, bro. There will be.
So that you produce it, we'll have it next week. Then we'll proceed further.
My prayer 4 also, my lords, is based on a decision of this honorable court confirmed by a division bench, which according to them, they are in appeal in the Supreme Court against that order. It is writ appeal 2 of 2019,
What
where
is
a
it?
direction.
What was the direction?
Direction was, my lords, that direct the appellant BDA to place the respondent in vacant and peaceful possession of scheduled land, more particularly so and so, within a period of 3 months. Notwithstanding above directions, it will always be open for BDA to take recourse to acquisition proceedings under 2013 Act by ensuring that a preliminary notification under Section 11 and of 2013 is issued. If such notification is issued within a period of 3 months, the direction issued to place the respondent in possession will become inoperative, provided acquisition are completed. In the event acquisition proceedings are not completed and compensation is not paid within reasonable time, we grant liberty to respondent to file a fresh petition.
No, we'll only be going in circles. We'll only be going in circles. You take a comprehensive view, taking note of all the litigations. You go through all the litigations and take a consolidated stand. There's no point in simply passing some order and pushing it away. So we'll have, when do you want it?
I have up to 10 days. But the only fact, all throughout, Lord, if the next significant can correct me, all these days before all the benches, it was an issue whether this land falls within the acquired area or not. Was an issue.
Yes.
Now it is clarified.
Correct.
It falls within the acquired area. Now, Lord, only the issue is whether I have to pay compensation or he'll have to go to the Supreme Court to claim compensation is the issue.
Then
And that
clarify.
I will assist your logic.
I'll have it on 9th.
That too
9th
after
Monday.
establishment of their right, my lord.
Huh?
That too after establishment of their right. Because as per the report, my lord, there is no
correct,
no
sir.
grant available
That,
in the
correct.
revenue authority.
In the reference,
Now
Tahsildar
whether,
would be a party.
huh?
In the reference, before the reference court, Tahsildar and Deputy Commissioner of the Bangalore urban would be a party.
No, that you place it on record. Let us have a look at the reference. Relist on 9th.
One submission, my lords. Insofar as my learned friend's submission is concerned, it is not established that it is acquired. It is established that possession has been taken. That is the crux of the matter, my lords.
Correct. So now they'll let them show the amount is deposited in reference. If so, on which reference and the reference proceeding. Relist on 9th. Counsel for the BDA to demonstrate whether reference is pending regarding the property which the petitioner has asserted, which is a subject matter of demarcation in the sketch filed along with the memo.
Kindly say reference is so far as survey number 1 of Jarakpande Kaval is concerned. But they
Bracket,
also claim survey number
bracket
1.
ಅಲ್ಲಿ survey number 1 of
Jarakpande Kaval.
Jarakpande Kaval.
My lords, just by itself, it will be misleading, my lords. I am just pointing out because the crux of the matter is Jarkamante Kaval village. Yelanka Hobli is my land. Yashwantpur Hobli is what is notified. That is exactly what is the finding given. So unless that part is clarified, this may not suffice. My lords.
Government educate to produce the village maps of Jarakpande Kaval.
My lord, already, my lord, we have already submitted our report, my lord. In that report, my lord, Jarakbande Kaval is there mentioned.
No, what is this Yelanka and Yashwantpura? You
Yelanka.
place the village maps
Please.
of both Yashwantpura and Yelanka. If
Please.
it's separate, you produce both, let us.
This issue cannot be clarified by way of the documents because at one point of the time it was there in Yelanka Hobli. Then at another point of a time.
That you find out.
Yashwantpura Hobli. But the
That you find out.
Transfer of records from this Hobli to that Hobli. There's not found in the ADLR's office. Also, but this is why this note of the ADLR has come. But there is another writ petition where the similar advantage was sought to be taken, but this honorable court has disposed of. Both the petitions were listed on the same day with this conversation. But at that point of the time, my learned friend had taken time to show that I'll get the grant records. At that point of the time, that's why this matter was there. Other matter,
Any of you find out originally where it was, whether there is change
The
in.
sketch melody is, it has been already noted.
Correct. In the village map and revenue records,
Yes.
you find out whether both are one and the same or different, etc.
Please.
Yes.
Other matters 25.
Pacho.
Anil Kumar.
I make a request to the lordship. My matter is serial number 45 next to where acquisition proceedings was involved. I have laid the pipe, not in this matter. We have laid the pipe. It is reaching the matter all the time, so listed, but not the. At our request, it is posted for the orders in the second day. May I request the lordship to have the matter and the orders listed.
My submission, my lords.
This number
I am-
one.
Let us see. I'm not taking it up today, but I'll fix a date.
Please,
Read
my
the
lords.
matter.
12th and 13th of
Same
next
stage
month.
on.
And in the list number one, my lord. Otherwise we won't read because government is suffering. List number one.
Yes.
Pacho.
Lord, may I make a mention? Lord, serial number 16, the list number 1, it's squarely covered by judgment of coordinate bench this court and confirmed by the division bench.
I'll consider. Let me, some parted matter, I have to take it up. We'll see.
Please.
Pass over, let us see. Yes.
Before my one request, my lord, before my learned senior counsel starts, two aspects, my lord, I missed out in my this thing. May seek your lordship's indulgence in.
Yes.
With respect to my lord, so your lordship initially did not agree with me when I made a mention that it is successive petition. I left it at that, my lord, but I think I request my lordship to see what is your lordship written in a order in the same case.
So successive?
I made an objection, my lord. It is a successive petition without change of circumstances because earlier they came under Article 226, where you filed an IA in a writ petition, where your lordship dismissed that IA, saying that there is passing certain observation. So therefore, I made a statement, my lord, that this is amounts to a successive petition. So since it is a successive petition, no change in circumstances. Question of entertainment of successive petition without changing circumstances is not amenable, is what my argument was. Where your lordship expressed it orally that no, I may not agree with the fact that it is successive, but I still your lordship may not agree with me that it is successive. But I think there are observation made by your lordship has to be looked into. My lord, I request your lordship to may request your lordship to take your lordship through those observations made in that petition. The petition copy itself, my lord, at page number 108 is the order on IA. In lordship may request your lordship to take the criminal petition 17538, my lord, filed by the petitioner. Page 108, my lord, is the order on IA. This is while allowing the Koka, your lordship has rejected the IA for anticipatory bail. Your lordship may see the observations made, my lord. The prayer, my lord, your lordship may see at para 45, your lordship has extracted the prayer. IA has been seeking following relief. Direction to the respondent police not to arrest the petitioner in connection with crime number 73 of 2025 registered by Bharatinagar police station, or alternatively grant bail to the petitioner in the event of his arrest. Pass other orders as required. Now your lordship may see the prayer in the present petition. Your lordship will find the prayer, my lord, is at page
27.
You're saying it's identical.
Identical. The prayer, my lord, says, may I read, my lord? Wherefore the petitioner most humbly prays this honorable court pleased to enlarge the petitioner's on bail in the event of his arrest in crime number 73 of 2025.
So you are contending that unless the subsequent events, you can't come.
That's precisely my point. And there is a reason why this anticipatory bail came to be rejected, my lord. Of course, your lordship has given two reasons, but the subsequent reasons, my lord, is one reason, my lord, that they come up because saying that the bar under section 18 of the Karnataka Organized Control Crimes Act. And subsequently, my lord, though your lordship said there is no bar now because Koka is gone, but your lordship, the observation made by your lordship in para 62, my lord, at page 114. Page 114, my lord.
Yes.
Para 62. Normally, the petitioner is entitled to go before a sessions court and seek an appropriate relief. Such legal option is open to the petitioner at this stage. This court finds no ground made out for the exercise of extraordinary power under Article 226 of the Constitution of India in the present proceedings to grant anticipatory bail to the petitioner. It is to be noted that the investigation in crime number 73 of 2025 is still not concluded. Though partial interrogation has been made, however, it is at the time of argument, respondent state has taken a stand that the custodial interrogation is required. Though this court may have the power to grant anticipatory bail in exercise of power under Article 226 of the Constitution of India, however, such exercise of power is exceptional circumstances which this court finds it absent in the present case. This is relevant, my lord. After looking into it, your lordship said that it is absent for the relevant in the present case, and your lordship exact the reason for absence in para 66. This court finds prima facie force in the contention of the learned additional state public prosecutor. The custodial interrogation, which is legal option available to the investigation agency, and there is no reasons to deny such exercise of power. Further, material would indicate that the deceased had in writing stated that henchmen of the petitioner had threatened him. In the light of the same, this court is not inclined to exercise extraordinary power on Article 226 of the Constitution of India, particularly in the light of the factual metrics referred to above. Furthermore, investigation is still to be completed, and an order of granting anticipatory bail may interfere with investigation of heinous offences. This is the observation of your lordship. Your lordship has come to two conclusions, my lord. One, custodial interrogation is required. Second, granting anticipatory bail at the stage when investigation is pending will interfere with investigation. These two aspects, my lord, as on today, still stand as it is. No change in these two stands.
I'll consider.
And the other aspect, my lord, your lordship may see the objection filed by the public prosecutor before the trial court. More particularly, my lord, at page 129. Page 129. Para 25, my lord. If A5 is enlarged on bail, likely to put hurdle in further investigation. This is the objection filed before the trial court, my lord. And para 26, my lord, if A5 is released on bail, likely to tamper with the prosecution witnesses. I demonstrated, my lord, by showing 164 statement of the complainant. She herself said and what circumstances she was forced to make such a certain statement. That itself shows that, my lord, in the tampering of investigation, tampering of witnesses. Let alone anticipatory bail, my lord, I say, my lord, even the regular bail in a case of this nature should not be granted, which going to have an impact on the witnesses to depose before the court. And then para 27, my lord, the objection also talked about custodial interrogation. Therefore, trial court, my lord, has gone into details of all these things, and then thereafter come to the conclusion saying that the present petitioner is not entitled for anticipatory bail.
Consider.
Yes, my lord.
But one point, I have one observation.
Yes.
Time and again, you are saying that the state police
yes, ma'am,
prima facie have not done their duty as per law.
I say, my lord, one step further.
And also, I'm saying.
Yes, ma'am.
Then, needless to state, at some point you should initiate action against them.
That is on the pipeline. I only say, my lord, that's on the pipeline. We have not touched that aspect because there are certain investigation has to happen. Once it is done, it is not just, we are also contemplating, my lord, there is in fact then other material which we have found. Not just departmental action, I think we are looking for something else also. That much I can assure you, my lord, your lordship, to that extent.
Because it should be straight. Now,
That's correct.
If you're saying something is wrong, then you must also show bona fides in furthering it.
No, but the only thing, my lord, if you do anything, if you precipitate now, which is going to have an impact on investigation itself. That's the reason we have not precipitated to that aspect. There one other aspect, my lord, I read one judgment. Your lordship may see my judgment compilation. My judgment compilation. Deepak Agarwal judgment, my lord, is page 78.
Yes.
This is, my lord, interim anticipatory bail was granted. Matter went to Supreme Court. Supreme Court said that since an interim anticipatory bail was granted, we will not interfere, but directed the trial court, the High Court, to decide the matter quickly, and then passed on one observation, my lord. At page 85, my lord, para 5. Page 85, para 5. I read this judgment, but this particular para, my lord, para 5. In the event, your lordship got it. In the event, if the accused person seeking anticipatory bail do not remain present personally before the High Court, their application shall not be taken up for hearing, and shall it be open to investigation officer to proceed arrest the accused person. The reason, my lord, initially I showed your lordship that under 438(1)(b), interim application could have been entertained, and if interim application is entertained, then the accused who obtains an interim order should be kept present before the court. Now, under 482 of BNS, there is no interim application possibility, and there is no such provision exists. Therefore, I am showing this particular judgment of Supreme Court, my lord, that the presence of the petitioner is required to be present in the event of to show his bona fides, etc. And in case if you want to take him to custody subsequently,
we'll see. Yes.
May please, my lords. Lords may kindly forgive me, my lords, in the event my lords feel some of my submissions borders on being a little harsh, if it comes to that, my lords. My lords, the manner in which I would give the reply to what has been argued would be under 4 steps, my lords. First, I will point out 18 circumstances, my lords, when considering an anticipatory bail after having heard the arguments, just to, because there was a 6 months investigation, just to understand throughout this investigation what has been gathered against the petitioner. That would be very crucial, my lords, to consider whether there is a prima facie case, whether any custodial interrogation is necessary, if it is to be done, how it can be given. For those aspects, my lords, what is it throughout this entire investigation that has been gathered? So for that purpose, my lords, there are about 18 aspects which I'm going to be pointing out, my lords, for the consideration of the present anticipatory bail. Then, my lords, I will even point out post that the manner in which, my lords, though at present we are not at a stage where this court is looking into the legality or otherwise of the interim anticipatory bail. We are not at that stage, my lords, and also my lords is not sitting on an appeal over the interim anticipatory bail. But however, we find, my lords, an entire session has been devoted only on making certain comments on the interim anticipatory bail, which I will give my reply to. Then the very list of dates and events which has been submitted by the prosecution, my lords, I will be able to demonstrate from their list itself the number of untrue statements that are there in that list. And then, my lords, the petitioner's cooperation during this entire investigation, one of the very crucial aspects which my lords may consider for the purposes of this petition. For the first aspect of my submission, my lords, the 18 important aspects that may be noticed, I've put it in the form of a bullet point itself, my lord, so that I save some time on those aspects. Could I just read the note itself, my lords? The most crucial aspect, sorry, it's page 1. The most crucial aspect for consideration of the allowing or rejection of this anticipatory bail is as to the materials collected against the petitioner during this entire investigation. Other than the prosecution trying to establish the familiarity of some of the accused with the petitioner, the prosecution during the investigation has failed to establish anything else significant. The travel done to Prayagraj by A1 with the petitioner and others during the month of February 2025, attending of A1 and others the birthday celebration of the petitioner in the month of March 2025, February 2025, and the call detail records during that time are all used to establish the acquaintance between the parties. Mere acquaintance between the parties would in no way establish an element of conspiracy, since there is no iota of evidence whatsoever pointing towards conspiracy, either in the form of a direct or circumstantial evidence. This is so far as conspiracy is concerned, my lords. The only other aspect that the prosecution intended pointing out was an alleged motive for the commission of the crime. The motive alleged pertains to certain complaints which had been given earlier. The said aspect of motive by itself, which is not supported by the other relevant circumstances, cannot be the sole ground for the rejection of the petition. It is often pointed out that the motive is double-edged weapon. The possibility of the petitioner being falsely implicated because of the deceased family being inimical to him cannot be ruled out at this stage. A mere reading of the complaint itself discloses that it is only on suspicion and hearsay the petitioner's name finds place in the first information report. Now the 18 aspects at page 2, my lords. During the course of argument on behalf of the prosecution and based on the 6 months investigation that has taken place, the prosecution has failed to point out any evidence in support of the chain of circumstances. The following 18 aspects are of relevance. There is nil evidence against the petitioner insofar as conspiracy is concerned. There is nil evidence against the petitioner insofar as preparation to commit the offense is concerned. There is nil evidence as regard any adverse conduct of the petitioner prior to the incident. There is no electronic evidence of any kind, be it CDRs, messages, or any other communication between the other accused and the petitioner prior to the incident on 15/7/2025. There is nil evidence of the presence of the petitioner anywhere close to the vicinity of the incident in question. There is nil evidence insofar as communication between the other accused and the petitioner immediately post the incident on 15/7/2025. There is no evidence as regard petitioner having any knowledge about this incident on 15/7/2025. There is no evidence of adverse conduct insofar as the petitioner is concerned immediately post 15/7/2025. There is no evidence of any extrajudicial confession as against the petitioner in relation to the incident. In none of the statements of the co-accused is there any implication or allegation against the petitioner. My lords, total number of accused are 20, including the petitioner. Next page, my lords. There is no allegation in any of the 19 remand reports pointing towards the role of the petitioner in the alleged incident. Even in the approval order of involving Koka, there is no allegation disclosing involvement of the petitioner in the incident in question. There is no scientific evidence pointing towards any incriminating circumstance as against this petitioner. The statements recorded of the petitioner by the jurisdictional police has not led to discovery of any fact under Section 27 of the Indian Evidence Act. In the charge sheet filed by the CID on 22/12/2025, there is nothing suggestive of the petitioner's involvement in this incident, and that's probably the reason why the petitioner is not arraigned as an accused in the said charge sheet. In other words, there's absolutely no prima facie case that has been gathered during this entire investigation done by CID, and probably that's the reason why the CID has not even summoned the petitioner once during their investigation that spanned approximately 5 months, 10 days. It is also relevant to once again indicate that the coordinate bench, while, my lords, coordinate benches, it was repeated orders, while passing protective orders, had permitted the prosecution to seek modification of the same if need arose. Despite the same, not once did the prosecution seek any modification so as to enable any custodial interrogation. Therefore, all that we have from the prosecution material is a case of acquaintance and nothing else. The only other aspect which was pointed out was that post the incident, it was seen that the tower location of accused 1 coincides with the tower location of accused 5. The prosecution has failed to produce any CDR in relation to any conversation between A1 and A5. They failed to indicate the latitude and longitude to establish that 2 persons were together at any given point of time. From the materials in the charge sheet, if any person travels anywhere close to the residence of A1, then the tower signals merely indicates the same. Without wanting to repeat the same, the conduct of the petitioner vis-a-vis the conduct of the investigating agency, which has been elaborately pointed out during the argument, may be considered. My lords, I did not want to again put the 2 conducts, my lords. My lords was pleased to make a note of how the conduct of the petitioner vis-a-vis conduct of CID. How CID, right from taking over this investigation within 7 days, would initiate Koka. 12/8 is when the initiation then takes it further. Never do they call me for any kind of questioning. And then finally, when they file their charge sheet after 5 months, 10 days, they don't arraign me as an accused, but merely say we are continuing investigation. So I didn't want to again elaborate it further, my lords. My lords was pleased to notice it at the time when I made my submissions. Now, my lords, in my respectful submission, my lords, this whole argument on this anticipatory bail would have revolved around these aspects, my lords, whether there's a prima facie case, whether he has interfered in any way with this investigation, whether any tampering that he has done, whether he is a flight risk. It would have revolved around these aspects. But what we find is, my lords, in the process of arguments, the argument commenced with the prosecution making several comments on the interim anticipatory bail which was granted on 26/12/2025. Let's my respectful submission, though it has nothing to do with the objection to the main anticipatory bail, the prosecution did make it a point to comment on the grant of the interim anticipatory bail. Now, my lords, the question is, if the prosecution was so aggrieved that this interim anticipatory bail ought not to have been given on the ground of whatever that they say, is it not open to them, my lords, to challenge the same before a superior court? Without doing so, my lords, and knowing fully well that my lords is not sitting on an appeal over that order, we have had an entire session only on this interim anticipatory bail. Now, my lords, I might not have commented too much on it, my lords, if the submission merely was to the effect of saying that interim anticipatory bail in the facts of this case should not have been granted to that extent. If it had been, my lords, probably I need not have replied back to it. But what really hurts us most is, my lords, The language that has been used against this grant is just not comprehensible, my lords. My lords, repeatedly it was submitted that this interim anticipatory bail granted on 26/12/2025 was obtained.
Well, let's not get into.
No, my lords, I need to, my
No,
lords,
in fact- in
I'm
fact, I
sorry,
used
my
it-
lords,
no, no.
I did not disturb Mr.
I am-
Jagdish
I
when he
am-
argued.
I am conscious of that word
My lords,
and I use that word.
They use the word, let me reply to it.
Yes, I
Yeah.
use that word. I'm conscious of
Yes,
that
my
word.
lords. Now that they say they used it consciously, my lords, what would the prosecution mean by the usage of the word obtained? And my lords, understandable, my lords, at some point of time when we make our submissions, the court granted. Instead of that, the word obtain, if it comes, my lords, understandable at some point of time. But if it's a conscious attempt to use words as obtained, which in my respectful submission, my lords, ought never to be used in a court of law, unless, my lords, you're going to be substantiating it with anything. Now, my lords, what we find is it is just not an oral submission of the usage of the word obtainment, but strangely, prosecution puts it down in writing. May I request my lords to have the statement of objections, 3 paragraphs where this has been highlighted. Kindly notice paragraph 7A, my lords, at page 2. My lords may notice at 7 small a, the last sentence, my lords, has been served and obtained an interim order by suppressing facts. One place, my lords. Thereafter, kindly notice 7D, my lords. Third line in 7D. Please also notice, my lords, paragraph 25. Now, all this is in writing, my lords. Paragraph 25. My lords should notice third line in paragraph 29 from the bottom, which will be about the 7th line from the bottom of that page. My lords should notice the word obtained interim order. My lords get set. Paragraph 25. 25. So my lords may notice, my lords, from the bottom of the page about 7 line upwards, obtained. My lords, it was also submitted. The obtaining of this interim order was well engineered. The other usage of language that we get is, my lords, the police machinery works for the petitioner. Please notice his words, my lords, but it will have serious bearing on how the submissions were done. The police machinery works for the petitioner. The obtaining of interim order was well engineered. The petitioner approaching the court has frustrated the process of law. The petitioner has kept the prosecution in the dark and insisted on passing orders and has indulged in interference. My lords, this is the submissions that have been done, my lords. My lords may not find it in that statement of objection, submissions that were done, that the petitioner has clout in the department. Police is hand in glove with the petitioner. Investigation has been done according to the whims and fancies of the petitioner. Petitioner is misleading the investigation. petitioner wants speedy investigation to be done, but not against him. And all these submissions we get is, my lords, when you're trying to point out an interim anticipatory bail, which you choose not to challenge before a superior forum. My lords, rather than the submission to be made on the merits of the case, my lords, if it is not subject matter of challenge before my lords, why would words like this be used? Is it to cause certain prejudice to the case? In effect, my lords, the prosecution is critical of two main stakeholders in the criminal justice dispensation. They're critical of their own police department and they're critical of the judiciary. My lords, would not usage of such language, my lords, in my respectful submission, amount to scandalizing or tending to lower the authority of this honorable court? And what is the need for such usage when you are trying to point out a case on merits? So will it not amount to interfering with the due administration of justice here, my lords? If you are aggrieved, whether on the maintainability of my interim application, whether you are aggrieved that I have made some suppression of facts, whether there should not have been an interim anticipatory bail granted at all, as pointed out today, my lords, by a judgment which they relied on, would it not have been taken up to the higher superior court? The case which they relied today, my lords, was a case where an interim anticipatory bail was granted. When it was taken up to Supreme Court did not interfere with it, but send it back to the High Court for consideration of the anticipatory bail. So why, my lords, why is this? Is it only to cause a prejudice? Are we trying to make a case very sensational rather than dealing with it on its own merits? My lords, when a state has challenged the quashment of Koka before the Supreme Court, my lords, and Supreme Court is made aware of the interim anticipatory bail granted, my lords, on behalf of the state, they submitted, we have not questioned the interim anticipatory bail. So why use words like betrayal, blatant lie, prosecution being kept in the dark and suppression of fact when you don't choose to challenge that order? My lords, normally we keep saying this, my lords, even we have donned the role of prosecutors. It's always considered, my lords, the role of a prosecutor, he's like a minister of justice, my lords. He's a minister of justice. He's expected to be absolutely dispassionate. My lords, the fear is when we don the role of a prosecutor, we should not be called a persecutor, my lords. He is expected to be fair to the state.
No, since he's making a statement against me, let me also show what is there in the thing. Since he's making a statement, I can demonstrate. If he wants to be, if you want to take it to the public, let him take it. If he's making allegation against me, I'm willing to show what is there. I'm not hiding.
One word that I have used, if one word that I have used is not part of these proceedings, let them point it out.
I'm not hiding anything.
Let them point it out.
I can demonstrate. I am not being a persecutor. I placed a material what is exist. You can't be making a statement against me saying that I am being a persecutor. Sorry.
Lords, I did not make a statement against Jagdish. I made a statement of what a fair public prosecutor would do.
Yes. What is the mean?
What is the meaning you can infer? That's different. But I'm saying role.
Exactly what I said.
Yes, my lords, the attempt should never be, my lords, in my respectful submission, to make a case sensational. Dispassionately, we will deal with the case, from both ends. So, my lords, I'll just stop with this, my lords. I may not want to comment more on what has been used as words. My lords, one important aspect that was pointed out is on my prayer, my lords. The prayer done in the anticipatory bail. If my lords would have page 27 of the petition, Please notice the prayer, my lords. Wherefore, the petitioner most humbly prays that this honorable court be pleased to enlarge the petitioner on bail in the event of his arrest in crime number 73 of 2025 on the file of Bhartinagar Police for offences punishable under section 103 and 190 of BNS in the interest of justice. My lords, by reading this prayer, they said we have suppressed facts. If my lords would notice, crime number 73 is indeed registered for offences under these two offences. Two important aspects may be noticed, my lords. Crime number 73 is for these two offences. Now, when they file a charge sheet, my lords, on 22/12/2025, I am not arraigned and accused. If I am not going to be arraigned and accused in a charge sheet which may have other offences, on what basis would I file my petition? And my petition was filed, my lords, after the charge sheet was filed where I am not arraigned as an accused. Can we find fault with the prayer, my lords? Crime number 73 pertains to these two offences. And to say, my lords, we have suppressed material facts by making this prayer. Deeply, my lords, I'm sorry, my lords, that's absolutely not so. Now, my lords, when the trial court, when the special court also considered this anticipatory bail for rejecting it, my lords may notice page 134. Please notice page 134, my lords. What was it that was filed even before the special court? My lords, order starts at page 133. Just 134, the first paragraph may be noticed, my lords. The very two offences, the same crime number. So why would you comment that it is suppression of material facts? And also, my lords, even though it is really not too relevant, a submission that was done is under the CRPC, section 438 provided the power to grant an interim anticipatory bail under CRPC. But similar provision is not there under section 482 of the BNSS. So therefore, the court has no power to consider any interim anticipatory bail. This was the very same argument that came up before the Bombay High Court, my lords. This was in the case of Chaugle and Co. versus the public prosecutor. My lords, 2024 SEC Online Bombay 2501. The relevant portion, my lords, the submission may be noticed at paragraph 13. Paragraph 13, my lords. Mr. Merchant, my lords gets that, would submit that there is no provision or scope under section 482 of BNSS to grant any interim protection or any interim bail. Such protection cannot be inferred or looked into when the legislature in its full wisdom did not incorporate such provision of ad interim bail, though it was available under section 438 of the Code of 1973. He submits that the intention of taking away such power has to be looked into, and the court cannot interpret what is not given under the said provision even by considering inherent power. Then, my lords, the answer to this reply, counter argument, we get at page 27, at paragraph 27 at page 6, my lords. Paragraph 27. Mr. Desai, 27, my lords. Mr. Desai would further submit that it is well settled proposition of law that if the court is having power to grant final relief in the form of bail in anticipation of arrest, the court is also having power to grant interim relief. For that purpose, there is no requirement of such power to be mentioned in the particular section, as it is inherent power to grant any relief till the application is decided. Mr. Desai would further submit that though under section 482 of BNSS, there is no mention of any power to grant interim relief, likewise, there is no restriction on the court. He therefore submits that the interpretation has to be for advancing justice and not scuttling the provisions. He submits that liberty of a person is of utmost importance as provided under Article 21 of Constitution of India, which cannot be curtailed except by the procedure established by law. When BNSS provides power to grant bail in anticipation of arrest, such power must be interpreted of having inherent power to grant interim relief. Otherwise, application itself would become infructuous in case the accused or the applicant is arrested before finally deciding the application. Now, my lords, the court at paragraph 45, my lords, page 10, where it formulates the points. Point number 3, which is formulated, is on this. Paragraph 45, point number 3. If it is observed that such bail application has to be considered under 482 of BNSS, whether the court is empowered, having jurisdiction to grant ad interim bail pending decision of the main bail application. Thereafter, my lords, point number 3 commences at paragraph 75, my lords. '75, page 17, my lords. So they discuss from 75 till 78, my lords. 79 may be noticed. It is thus clear that the amendment of 2005 in CRPC, and more specifically inserting clause 1 to 4 in section 438, was not given effect to till date, though it was in the statute book, my lords. There was no notification for bringing it into force. Thus, the original 438(1) reads thus. They extract how 438(1) was, my lords. Paragraph 80. The provisions of section 482 of BNS, and more particularly subsection 1, is pari materia with the provisions of 438(1) as quoted above. Thus, as rightly pointed out by Mr. So-and-so, the observation of the constitutional bench of the apex court in the case of Gurbak shall apply with full force to section 482 of BNSS. Then, my lords, after that we get Gurbak Singh Sibia being quoted, my lords, extensively. At paragraph 46, 86, 87, we get that. 88 is how the court then interprets. Thus, there is absolutely no need to further discussion in respect of the power of the Sessions Court or of this court with regard to grant of ad interim relief pending application of bail in anticipation of arrest. Such power clearly exists as inherent powers under the provision of grant of bail. However, it is also clear that even while granting ad interim relief, there has to be a subjective satisfaction of the court, and such ad interim relief should be on certain conditions and not blanket. It is required to be considered on the premise of Article 21 of the Constitution of India, which is clearly traceable with an intent to protect life and liberty of a person, and more particularly to avoid unnecessary arrests, as well as to avoid any harassment in the hands of the investigating agency. Paragraph 90, my lords. In the case of grant of bail, however, it is also clear that even while granting ad interim relief, there has to be a subjective satisfaction. 93. Having given anxious consideration to all the above aspects, it is clear that while considering an application under 482 of BNSS, the court is having inherent power to grant ad interim bail in deserving cases, and by exercising its discretion on case-to-case basis. Then below that, paragraph 94, point number 3 is C is answered, my lords. So this is insofar as the maintainability itself of an ad interim relief, my lords. Now may I come to the
So in the Sangeeta Kacheri, now we are coming to the main part with all the preamble ragas. Yes.
Because we did not have text.
But without that, you can't start the
No,
main.
my lords, it's not possible. Because that was one of the strong points which was pointed out as though we came without any jurisdiction.
No, no.
I'm sorry, my lords, if that's taken some
No,
time.
that's okay. Yes.
My lords, could I request my lords to have the list of dates and events given by the prosecution?
I'm not going to be very caustic. Justice Vallinayagam used to say, after I've argued, now come to the point.
But there, my lords, I think arguments used to get over very fast. Very fast.
Very fast. And the board used to run disposal.
Yes. I think a lot of RSAs during that time that we had. My lords.
Yes.
My lords, could I request my lords to have the list of dates and events which they had given? Because I will point out from their list of dates and events itself.
Yes.
My lords, could I start with the list of dates today or continue tomorrow, my lords? Because this list of dates will take a little time, my lords.
We'll continue tomorrow.
Tomorrow, yes. Because I understand my lords has even a pronouncement.
Nobody understands the judge's plight.
No, but sometimes, my lords,
No, we'll continue tomorrow.
Yes.
Relist tomorrow.
Obliged.
Movement of order, serial number 64, Sunil Kumar S, Chandra Kumar P.
Accordingly, petition is rejected subject to the above observations. All contentions of the petitioner regarding grounds made out for him to be enlarged on bail are kept open. It's made clear court has not recorded any finding regarding the merits of the claim and has merely disposed of the petition, holding that the petitioner is required to have approached the apex court itself. Headful.
Court officer.
61 days.
Court officer, ಇದು ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತು ಲಿಸ್ಟ್ ನಂಬರ್ 39.
So serial number 61.
Second list, serial number 51.
Physical MLA, sir.
Serial number 61. So serial number 61, list number 2. 21. Serial number 61, list number 2. Corrected marks. Date put this a short date.
So 60.
ಆರ್ಡರ್ಸ್ ಲಿಸ್ಟ್ ಬರುತ್ತೆ 30 ತಾರೀಕು ಬರುತ್ತೆ.
21 sir. List number 121.
List 129. List 129.
List 129.
Court officer?
21.
Date ಕೊಟ್ಬಿಡಿ ಸರ್, ಅದೇ ಸ್ಮಾಲ್ ಮ್ಯಾಟರ್.
21. 21.
Court officer?
ಆದ್ಮೇಲೆ ಆನ್ಲೈನ್ ತಗೊಂತಾರಂತೆ ಮೇಡಮ್.
21.
List 2?
List 126.
List 261.
Court officer, list 2, serial number 59.
List 61 is ready.
List 261. 21. List number 1.
List number 121 Sukumaran G.
26.
ಅಲ್ಲ ನ್ಯೂ ಮ್ಯಾಟರ್ ಡೇಟ್ ಕೊಡಲ್ಲ. 24ನೇ ಮ್ಯಾಟರ್ 25 24.
26.
ನಾನು ಇಂಟರ್ನೆಟ್ ಡೇಟ್ ಬರ್ಕೊಂಡಿರ್ತೀರಿ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲ. 54 ನಂಬರ್ ಹೇಳಿ ನಾನು ನೋಡಿ 58 54 ಇದೆ 16
46 ಅದು ಇವತ್ತು ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು ಸರ್.
Court officer?
ಇಲ್ಲ ಅದು 3 ಇಲ್ಲ 4 ಕೊಟ್ಬಿಡಿ ಸರ್, ಬರೋಲ್ಲ ಹಾಕ್ತೀರಾ? ಅದು ಡೇಟ್ ಕೊಡ್ತೀರಾ?
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ ಕರೆಕ್ಟ್ ಆಗಿದೆಯಾ? ಚೆಕ್ ಮಾಡಿ 61 ಅಂತ ಬರುತ್ತೆ.
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 61. ಆನ್ಲೈನ್ ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ
ಯಾವ್ದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡೋದು?
ಈಗ ಮತ್ತೆ ಆಮೇಲೆ ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ ನೋಡ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಸೀರಿಯಲ್ ನಂಬರ್ 39 ಲಿಸ್ಟ್ ನಂಬರ್ 2
ಯಾರಿಗೂ ಡೇಟ್ ಕೊಡ್ತಾರೆ,
ನಾಡಿದ್ದು ಹಾಕೋಬೇಕು ಸರ್. ಅದು ಡೇಟ್ ಗಿವನ್ ಇತ್ತು, ಪಾಸ್ವರ್ಡ್ ಆಗಿತ್ತು.
ಅದಕ್ಕೆ ಲಾಸ್ಟಿಗೆ ಕೇಳೋಣ ಅಂತ ನಿಂತಿದ್ದು. ಎಲ್ಲರದಾದ್ಮೇಲೆ ಕಿರಿಕಿರಿ ಬೇಡ. ಏನೊಂದು ವ್ಯವಸ್ಥೆ ಇಲ್ಲ ನೋಡ್ರಿ ಸರ್.
ಸರ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಕೋರ್ಟ್ ಆಫೀಸರ್
ಏನಾಯ್ತು?
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಓಲ್ಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲ ನ್ಯೂ
ಆಯ್ತು. ಈಗ ಇಲ್ಲಿ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ. ಆಯ್ತಾ ಬೇರೆ ಮ್ಯಾಟ್ರ್ ಇದೆಯಾ?
ಎಂಟ್ರಿ ಮಾಡೋದಿದೆ ಅದಕ್ಕೆ
ಸರಿ
ಎಂಟ್ರಿ ಮಾಡೋದಿದೆಯಲ್ಲ ಅದಕ್ಕೆ ಡೇಟ್ ಕೊಡಲ್ಲ.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ರಜೆ ಪೃಥ್ವಿನ ನಾನು ನೋಡ್ತೇನೆ ಅಲ್ಲಿ ಇದೆ ಅಂತ
ಡೇಟ್ ಕೊಡ್ತೇನೆ.
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್
ಎಂಟ್ರಿ ಮಾಡೋದಿದೆ ಡೇಟ್ ನೀವು ಅಗೇನ್ಸ್ಟ್ ಅಲ್ವಾ ಡೇಟ್ 100% ಇದು ಕರೆಕ್ಟೆಡ್ ಅಲ್ಲಿ ಇದೆಯಂತೆ 61.2 ನಲ್ಲಿ ಇದೆಯಂತೆ. ಒಂದ್ಸರಿ ನೋಡ್ಬೋದು. 61 ಪಾಯಿಂಟ್ ನಾನು ಚೆಕ್ ಮಾಡಿದ್ರೆ ಇರ್ಲಿಲ್ಲ ಅಲ್ಲಿ. 61.2 6206 ಅಲ್ಲಿ ಇದೆ. 62 ಇದು ಒಂದು ಎರಡು
Court officer?
One second sir, one second. ಅಪ್ಡೇಟ್ ಆಗುತ್ತೆ. ಅಪ್ಡೇಟ್ ಆಗುತ್ತೆ. ಡೇಟ್ ನೋಡ್ಕೊಡ್ತೀನಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಲ್ಲ ನೋಡ್ಕೊಡ್ತೀನಿ ಸರ್. ಹೇಳಿ ಸರ್ ವಿಸಿ ಕೊಡ್ತೀನಿ.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 39 ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಅದು ಡೇಟ್ ಗಿವನ್ ಇತ್ತು, ನಾಡಿದ್ದು ಆಗುತ್ತಾ ಸರ್ ಅದು?
39 ನಂಬರ್ 2 39 1 ನಿಮಿಷ.
Court officer, list number 2, serial number 59.
39 SB.
Yes sir. 3ನೇ ತಾರೀಕು ಆಯ್ತು.
ಸಂಜೆ ಹೇಳಿ.
Court officer, serial number 59.
ಸರ್ ಅದು ಆರ್ಡರ್ಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬರಬೇಕು ಅಂತ.
ಆಯ್ತು ಸರ್.
ಓಕೆ ಸರ್.
ಅದರಲ್ಲಿ ಬರುತ್ತೆ, ಸೇಮ್ ಸ್ಟೇಜ್ ಅಲ್ಲೇ ಬರುತ್ತೆ 59.
Court officer, serial number 59 list 2 ನಲ್ಲಿ
ಅದರಲ್ಲೂ ನಮ್ಗೆ ಕಾಣಿಸ್ತಾ ಇಲ್ಲ ಅದಕ್ಕೆ.
Court officer?
ಆಗಿದೆ ಸರ್ ನಿಮ್ದ್ರಲ್ಲಿ ಸರ್ ನಿಮ್ದು ಎಷ್ಟು 61 ಅದರಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ ಬಿ ವಚನ್ ಅಲ್ಲ ಸರ್ ಅವ್ರು ಹಾಕಿದ್ರು ನೀವು ಹಾಕಿದ್ರಲ್ಲ ಇದರಲ್ಲಿ 61.4 ಇಲ್ಲ 61.4 ನೋಡಿ ಚೆಕ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ 23 ಎಷ್ಟು 2 ನಾ ಎಷ್ಟು 123 23 ಡೇಟ್ ಕೊಡ್ತೀನಿ JR ಮೋಹನ್ ಡೇಟ್ ಕೊಡ್ತೀನಿ ಹತ್ರನೇ ಕೊಡ್ತೀನಿ ನೋಡಿ ಚೆಕ್ ಮಾಡಿ ಫ್ರೈಡೆ ಅಲ್ವಾ ಆಯ್ತು
Court officer, sir.
ಹೇಳಿ ಮೇಡಮ್
List number 2, serial number 63.
61 ಅಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ
ಅಲ್ಲ ಸರ್ 63 63
63 ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ ಮೇಡಮ್.
ಡೇಟ್ ಏನಿದೆ ಸರ್?
ಡೇಟ್ 2025 ಮ್ಯಾಟರ್ ಡೇಟ್ ಇಲ್ಲ, ಓಲ್ಡ್ ಮ್ಯಾಟರ್ ಫಸ್ಟ್ ಕೊಡ್ತಾರೆ.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಸೀರಿಯಲ್ ನಂಬರ್ 59 ಲಿಸ್ಟ್ 2 ಸರ್.
ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 59.
ಹಾ ಸರ್.
2 ವೀಕ್ಸ್
ಸರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಒಂದು ಡೇಟ್ ಹಾಕಕ್ಕಾಗತ್ತಾ?
ವಿನಯ್ ಕುಲಕರ್ಣಿ ರಿಜೆಕ್ಟೆಡ್.
ಲಾಸ್ಟ್ ಏನು ಹೇಳಿದೆ ಸರ್? ಇಲ್ಲೇ ಹೇಳಿದೆ ಸರ್.
ಅಪ್ರೋಚ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ 61 ಸರ್.
61 ಇಂಪ್ಲಿಮೆಂಟ್ ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಯಾವುದು ಅಂತ ನೋಡಿ ಕೊಡ್ತೀನಿ ನಾನು ಹೇಳಿದೆ
ಸರ್. ಇದು ಲಿಸ್ಟ್ 2
ಅದನ್ನ ಡೇಟ್ ಕೊಟ್ಟು ಮೇಲೆ ಬರುತ್ತೆ ಅದು.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್.
ಹೇಳಿ ಮೇಡಮ್.
ಸರ್ 59 ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ಕೊಡಕ್ಕಾಗತ್ತಾ ಸರ್? ಎನಿ ಡೇಟ್?
ಮಾಡ್ತೀನಿ.